Page number 1, item number 1 to 4. Page number 2, item number 5 to 13.
Lords, item number 10, I pay 1 week time to remove the defects, my lords. There are 4 or 5 defects, my lords, which has been pointed out.
You are Mr. Sahu.
Yes, my lords.
The request to Mr. S. Saul and counsel appearing for the appellant. The matter is listed on 27th of September 2023.
My lord, sorry, my lord, I am for the respondent.
This is a difficult. The board is congested. Find out a date whether that can be before that. 11 September. While the defects is identified by the registry shall be removed, no further accommodation will be made. This mention has been made in presence of Mr. S. K. Paul and counsel appearing for the sole respondent.
Page 3, item 14 to 22. Page 4, item 23 to 27. Page 5, item 28 to 33. Page number 6, item 34 and 35. Page number 10, item 36 to 38. Page 13, item 39. Page 14, item 40. Page number 24, item 40. Page number 24, item 42. Page number 25, item 43 to 46. Page 26, item 47 to 49. Page 27, item 50 to 54.
Item 51, my lord. I pray, my lord, if possible, my kindly taken out, my lord.
To be there. We'll try to take up the matter in the second session, okay?
Page 28, item 55 and 56.
May I please, Lordship? Lordship, item number 55, my lord. Lordship, in the senior advocate Vikram Raj leading in this matter, but due to some personal difficulty, he could not reach today. Yet we also, my lordship, pray for a short accommodation. I have taken the consent of Learned Deputy Solicitor General.
The matter will be listed on 11th of September 2023.
Interim order to continue, my lord.
Just a minute. The request of Mr. Meanwhile, the defects is identified by the registry. Shall be removed, and for that, no further accommodation will be made. Interim orders, if any passed earlier, shall continue.
Lordship, I'm in the second matter. In here, I think there's no defect, my lord. It's 32208 of 2021.
There is leading.
Bagadi Brothers was in.
No, there is no, but we are as this order in 13992.
Lordship, I'm in 32208, second item.
Okay, same order. There is also interim order is there.
Yes, my lord. In 32208, your lordship, interim order is there. I'm not sure about the first one.
Okay.
Keep you obliged, my lord.
Page 31, item 57.
It's only that the most part will not be there. Yes.
Item 57 to 61. Item 62 to 67.
59 minutes. Item number 59 minutes. That's a case of regulation minutes. Where we pray this matter to be taken up today minutes.
59.
Yes, minutes.
Is it 23 matter? And there is one defect also, you have not removed it.
Status file is later payment. Item number 59 minutes.
Well, it will remove the defects.
All right.
Lordship, may fix this matter after a week.
All right, after a week. 11th of September. At the request of Mr. Arnav Behra, and original training council appearing with the appellate. Meanwhile, the defect as identified by the registry shall be removed. No further recommendation from the purpose in this court.
Interim order may be continued.
Interest. You have Mr. A. Tripathi.
Yes, please.
Mr. A. Tripathi and council appears with the Sole respondent, interim order is passed earlier, shall continue.
There's seven respondents in it.
You are written for all
Yes, right.
respondents.
Yes.
Right. That's not sole. Interim order is passed earlier, shall continue until further orders.
Page 32, item 62 to 67.
We are disposing the where is Mr. Tripathi? There is for the applicant. Since we have passed the interim order, will continue until further orders. We dispose of this application. This interlocutory, this limitation application has not been disposed of as yet.
677 days delay, my lord.
Until further, not further order till the next date. Okay.
Page 32, item 62 to 67. Page 33, item 68 to 71.
Pardon to mention, Lordship, item 68 on behalf of Mrs. Sunanda Vishwa, Lordship, she is at Hyderabad son's health issue, Lordship. One capital, Lordship.
The problem is, have you seen the age of the case?
Yes, Lordship, she has been allotted this matter.
29, the 5th or 29 August. We are fixing on 29th of August, and no further accommodation will be made.
29th, Lordship, one capital, Lordship. She is at Hyderabad at the son's health issue. This 7 days will take she to return, Lordship.
There are other competent counsels are there.
No, my lord, the legal aid matter, Lordship, she has been allotted, Mr. Sunanda Vishwa.
31st plot of letters, there are a lot of 11-9. As request has been made from Ms. Sunanda Vishwa and counsel looking into the legal counsel looking into the let the matter be rejected. 11th of September 2023. It is made absolutely clear on that day. Legal counsel shall not be allowed to take any accommodation from this court. Yes.
Page 34, item 72. Page 35, item 73. Page 36, item 74.
No, please, my lord, this matter may be taken after 1 week, my lord. This is an elephant related public interest litigation.
Lordship, I'm sorry. Lordship, I'm sorry. I'm one of the petitioner. We are suffering a lot because of the wild elephant, Lordship. So this matter may kindly be taken up. This matter may kindly be taken up. Item 74, Lordship.
But you are seeing the objection. Let us think of
He is petitioner in one of the connected matter, but the main petition is of Mr. Mishra. In which all the affidavits are filed. These Lordship may fix it to any date 1 week after any date valid.
Lordship, I am sorry. The wildlife chief warden and also the under the leadership of the chief secretary, Lordship, there was a meeting. And on 10th August, the wildlife department people, they have visited to our land. And they have also told that there should be a canal above our land, which is dissect the mountain and our land, Lordship. On 10th August, they have visited. Lordship, this matter may kindly
saying all these things, I don't know. Your Lordship may fix it to any date 2 p.m. because that is it is a matter to be heard at a particular
29th it will come again.
On 29th, 2 p.m. 10:30. 10:30. 29 on 10:30. First item. Usually this matter is taken at 10:30.
No.
Previously,
Right.
but previously it was taken as 10:30.
It's all right.
Yes, ma'am.
Let it come at 2. Let's see.
29.
2 p.m.
Lordship, in the meantime, the copy which the affidavit which has been filed, that copy may kindly be served upon us, Lordship.
All right.
Lordship, what I pray, the affidavit which has been filed by Lordship,
Just a minute, you have the request to Mr. Astral and come.
He is always on VC. How can I solve? Let him come to court, I will solve it.
Lordship, I will collect. I
He is
will collect.
on each state, he is on VC.
He is volunteering that he collect, yes.
You
he
collect it from Advocate General Office, that is better.
Lordship, I will collect it from the London Advocate General.
All right. Request to Mr. A.K. Astral and Council, we can let the matter be listed on 29th September at 2 p.m. August, sorry, August 2 p.m. Stop. Mr. D.K. Mohanty, Regional Government Advocate is appealed for the state respondent. All right. What is the connect? There is another connected matter with this?
Yes, ma'am.
Well, is this matter is WPC number? There is there, huh? Yes, all the things. Those matters are just counting this in terms of the order questions and answers.
Maybe pardon, my lord. I'm so sorry for causing inconvenience to your lordship. Item number 29, my lord. I know your lordship's view that I have missed the bus, my lord, when it was called for, my lord. I extended apology, my lord, for mentioning this matter. With a defect in this matter, I'll remove the defect. Lordship, keep this matter to any other day, my lord.
All right, just let me complete this part and then I will.
My lord, I'm sorry. So sorry.
Over. 29 is over. So in item 29, the request of Mr. BP Pradhan and Additional Government Advocate appearing to the appellant, let the matter be listed on 26 September 2020. Meanwhile, the defects is identified.
I'm sorry for causing inconvenience to your lordship.
Moved. You're not. You are not on the capacity of the additional government advocate? No.
I'm additional government advocate, but in this case, I'm appearing for the Odisha Power Transmission Corporation Limited. I'm so sorry.
Let it cancel. Okay. BP 340, yes.
I may pardon to make a mention of the fresh state appeal. Any date next week, there is a contempt.
Yes.
I beg your pardon, my lord. Matter pertaining to issuance of license in a Clinical Establishment Act. It was before my lord's Justice Roth. But notice was issued by special messenger. Could not be taken up because my lord's expressed his inability to take up the matter. And to make mention before your lord.
So just mention before the registered judicial, I have given instruction. You will ask for the assigning the best.
Not so much. Yes. I'll just.
Pardon to mention, my lord, read appeal number 1692/2023, fresh additional matter of family issue. Pardon to make a mention, my lord. This case, my lord, I filed the POL and my personal capacity, my lord. There are a lot of allegations against the with regard to that construction of somewhere, my lord. During my breakup, my house, my lord. It was not listed, my lord. I filed several memos, my lord. Because there was a defect, and I had already removed the defect, my lord.
Lord Counsel, next time when you appear before the court for the personal matter,
Yes, ma'am.
where the brand and the
Yes, ma'am. Because I am assuming that is the reason that I have.
so this will also apply for the mention.
Oh, no, no.
Always give the your mention.
ma'am.
Take all the list. Supplement the list, fresh addition item number 1.
Name Visualist. The impugn order is under Annex 1, my lord, passed by the Honorable Single Judgment. The fact of the case is that, my lord, the land of 4 decimil was settled in the name of the petitioner, my lord, because he is a landless person, my lord. Subsequently, the villagers filed an objection and that was set aside. And he filed an appeal. And in appellate court, he lost, my lord. In the revisional court, he also lost, my lord. Thereafter, he filed a writ application, my lord.
Yes.
When a person is, my lord, landless, my lord, the settlement of land is not illegal or wrong, my lord. Your lordship may kindly see section 7(1)(a), my lord, of the OPLA Act.
Whether the court has the jurisdiction to decide all these matters.
No, man.
So you have approached the appropriate authority.
Yes.
They have decided.
Yes.
How this can be? We are not appropriate authority.
Not the competent authority is Tahsildar, my lord.
he has rightly observed that the petitioner is a landless person. And settled.
That observation of the Tahsildar has been reversed by the
That is subject to affirmation by the appellate authority or the revisional authority.
Yes.
So not that he is final and conclusive.
But without any observation, my lord, only this reverse the order.
You are given notice, I believe. You are given notice to
He
appear.
has contested the case. All along he was contesting.
Then how the court can revise this? Moreover, these are all concurrent findings
My lord.
and relating to fact, whether you landless or not, the court cannot determine it.
No, my lord. But Tahsildar is the appropriate authority to decide whether he is landless or not.
Tahsildar is not the appropriate authority. The appropriate authority is the ADM. Have you seen 7A?
ADM is the appellate.
Have you seen the
That's it.
7A? Subdivisional magistrate, subdivisional. You see the 7A.
Authority is the subdivisional.
Give the OPL Act.
Clearly.
OPL.
We grant the liberty to the appellant to file a fresh application for considering the allotment.
Obliged. Yes.
Nothing else. We will not interfere in any of the judgments.
Obliged.
Which will be considered in accordance with law.
Obviously, if he is a landless, the government under the policy can consider whether some land can be.
Yes, that is fair enough.
Ah.
Sorry, I was saying 7A, it's 8A.
No, this is for the encroachment more than 30 years. He had been given allotment, fresh allotment as a landless person.
Then it will not encroachment.
Yes. Heard Mr. K.K. Raut on counsel appealing for the appellant by means of this intercourt appeal. The order dated 18/2/2016, passed in WPC number 22887 of 2015 by the learned single judge. In the writ petition, the appellant had challenged the order. What is the date of the order? Dated such and such. This time giving the date. Can the order dated
18/2/2016.
Are you getting that in the order? The order starting with writ petition? The order of the additional district magistrate, RATHO, within bracket annexure 6 to the writ petition, and the order of the sub collector Athagar, annexure 3 and 4 to the writ petition. The order of the Tahsildar. No, by the order dated by the order dated 24/11/2015, the collector and the district magistrate, Cuttack, affirm the order dated (24/3/2008), passed by the sub-collector Attagar, Annexure 3, the writ petition. By the order dated 24/3/2008, the sub-collector Attagar certified the order of allotment made in favor of the appellant, having appreciated the report of the Tahsildar filed after the field inquiry. So it has been stated that the appellant has been living separately from his parents, and he has landed, and he has no landed property, and his annual income is 10,000 from all sources. So, it has been also stated in the said order of Tahsildar that the appellant is unauthorized occupants of a landed of the land, unauthorized occupation. So, the Tahsildar had suggested that without evicting such persons from the land, in his favor, the allotment should be made in terms of Section 8A.
No. He has not given, he has given, but
Maybe
that
allotment may
order
be
says that there has been no inquiry.
Stop. This observation was reversed, holding that there was no inquiry at all.
Page 36.
Stop. The said order has been affirmed by the collector and district magistrate by the order dated 24/11/2015, Annexure 6 to the writ petition. So, by means of this writ petition, this factual finding has been challenged. So this court is unable to interfere at concurrent finding of the statutory authorities by invoking its jurisdiction under Article 226 of the Constitution of India. So, as such, this writ petition is, the writ appeal is dismissed. So, before parting with the records, we observed that the petitioner, the appellant may file a fresh representation assigning the grounds for allotment of the land to the Tahsildar. On such applications being made, Tahsildar make the necessary inquiries and pass the order in accordance with law. Mr. D.K. Mohanty, Regional Government Advocate, has appeared for the state opposite parties. Urgent certificate copy that was at next.
Item number 2.
Item number 2, Your Lordship, the impugned order of the learned single judge is at annexure 1. Why this order, Your Lordship?
Yes.
The case of the writ petitioners has been dismissed on the grounds that given in para 5, Your Lordship. The commissioner dismissed the revision holding that the petitioners could not produce any material to show that they are in possession of 0.16 decimals of land which they want to record in their name. The matter in dispute is, Your Lordship, the petitioner, father of the petitioners, purchased a piece, was in possession of 0.51 decimal of land, Your Lordship.
Yes.
But they were in possession of that. But when Your Lordship, when the measurement was made,
Yes.
in final settlement, they saw that 0.16 decimal was reduced, for which they approached the learned trial court, Your Lordship. In the trial, Your Lordship, the matter order was dismissed, saying that they could not show any documents related to the possession of 0.51, which is not in fact, because all the documents was filed along with the written note of argument, Your Lordship, during hearing.
Written of argument is not document.
But it was filed later, Your Lordship.
No, it is not a document. They say you could not show any document.
Yes, Your Lordship.
Documents means the public record or other private document
Yes.
which can support that you are in possession. They say there is no such.
Yes, Your Lordship, it was given the documents.
In a writ petition?
Not in a writ petition, Your Lordship. The possession of land was admitted by the power of attorney holders of the defendants. Then it was, when the Munserim list was made, it was mentioned there 0.51. So
I'm asking you one thing, how under a 226 these matters can be adjudicated? It is a matter of recording evidence. Can it be done? Tell me, show any law. Everything cannot be made under 226 or 226. It is a matter of suit because it is a dispute relating to the possession, not relating to the settlement record. If it was a dispute relating to the settlement record, we understand that such civil suit cannot be instituted. But when it is a pure and simple question of possession, we are coming under the Article 227 or 226. If there is an alternative reason, show us that this is the alternative reason. Show us the alternative reasons.
the alternative reason, Your Lordship, now they
And moreover, this come to this impugned order you are showing to us.
Yes, Your Lordship.
The order is 22/9/2014.
That is what I wanted to submit.
How
He has annexed a wrong order.
Just read yourself, read it, page 13.
Page 13 of the constitution. That order is a wrong order you have annexed.
How that can be challenged?
No, this order is not challenged. In fact, she has challenged the final order, but she has enclosed the interim order.
What is the final order?
Where
that
is
is-
the interim?
You have showing the annexure 1 is the copy of the impugned order.
Yes, Your Lordship, it is there in my.
But this in annexure 1, this is the order that
Page
is open.
13.
Yes, page 13 is something other. This is an order dated 22/9/2014, not the order dated 6/1/2020.
That is also my copy sheet. This copy she has served on me.
There is some mistake, Your Lordship. May I be granted 1 week's time to rectify it?
What kind
Because in my copy, Your Lordship, it is the impugned order is annexed, Your Lordship.
Give the
some-
physical copy of
No, you see the consolidated writ petition after amendment.
After amendment, I
No, this is the order you have annexed.
because I may be pardoned, Your Lordship.
No, this appears maybe the mistake has been done also by the office.
Yes, Your Lordship, because in my
The
copy, it
office
is.
should have pointed out also.
No, they have filed the 6/1/2020 order in the main petition. Where is it? Huh? Just take note and just immediately report to the section. Next time I see, I will take action against them. Yes, argue this, they'll show. I will do a copy of the 6/1 order.
No, it's not with me. I am also having the copy of that interim order. Last on 26th.
Listed on 29th of August 2023 at the request of MS Chitra Pari, looking with the appellant. Mr. Pari is requested to correct, to replace the order, replace the impugned orders from the copy that has been served on the government counsel's office.
Change code.
So, the order that has to be provided in the paperwork is order dated 6/1/2020. So, Mr. D.K. Mohanty and counsel is referred for the petition, but you are to answer our questions
Yes,
about the
alternative, why I am approaching,
Why have you come here?
yes, Your Lordship.
SR has also, page has also not been scanned. Then SR page can scanning.
Just take up this matter, mark the file and show them that what they have done.
Right.
Yes.
Item number 3.
Immediately,
Yes.
in this case, the appellant challenging the order dated 26/10/2001 passed by the Honorable Single Judge in application number 1722 procedure 299, my lord. That is the impugned order at annexure 3, my lord. Prior to that, the case of the appellant is that he has joined in the Vinakrishna College, Jaleshwar, my lord, in the year 17/4/1984.
Yes.
And that post is approved by the government by which order dated 21/4/93 with effect from 7/2/1984, my lord, under the granting and principles. And initially his pay was 254, 252, so and so, my lord.
Yes.
But he has got his payment in the year 1998, my lord.
Learn counsel, your appeal is barred by limitation.
No, my lord, with that my lord, after 98, I wrote the point, and thereafter the principal, that is at annexure 1, my lord, after entire read, I have annexed, and where the annexure 3 series, my lord, all the representative recommendation at page 34 to 37 of the principal. My lord, here the point is that the
Just to wait. It appears from the stamp reporting that there is no delay. So when we only said observation, this interlocutory application is this court of essential. So these are I-189, you know. You have not provided a proper second copy.
of my lord writ of will.
Please.
Item 3.
Second copy file is not in order. You have not filed a certified copy according to the registry. You have filed a photocopy of the impugned order, and there is no application for dispensing with the certified copy.
Only one defect is found. Need copy of page 59 and 63, not filed. Other will be removed.
You have filed the certified copy.
My lord, I filed my lord, I will check up, my lord. According to me,
We just check up the matter. We'll take some other day.
my lord,
You will wait. 11th September.
my lord.
Use the matter on 11th September. Meanwhile, the defect certified by the registry shall be removed.
Item number 4.
May I please, Your Lordship? Is that the impugned order is at page 83 of the Learned Civil Judge. That an award passed by the permanent Lok Adalat has been set aside on the ground that since the opposite parties have not participated in the term of settlement, so therefore the permanent Lok Adalat has no jurisdiction to pass the award. And that is the finding. On that basis, the writ petition has been dismissed. But what happened in this case, the permanent Lok Adalat, well, we filed that there is a contract between the builder and the present appellant for allotment of a flat in an apartment in 2005 with a total cost of the amount 8,92,000. And he advanced rupees 3 lakh some odd at the time of agreement. And the flat was agreed to be handover within 1 year. And that was not handover. And in the process, 12 years have been passed. He did not hand over the flat and demanded another 40 lakhs. So therefore, and there is a conciliation and he agreed to pay the 11 lakhs as a compensation. The present appellant did not agree and he approached the permanent Lok Adalat, filing application. Thereafter, the permanent Lok Adalat issued the notice to the respondents on 18/3/2019. And they, in pursuance to such notice, they appeared before the permanent Lok Adalat. Thereafter, they did not appear for a considerable length of time. Then the permanent Lok Adalat framed a formulated terms of possible settlement. Possible settlement, and it was communicated to them.
Yes.
They did not appear.
So it has become the settlement? So it has become the settlement?
No, it is not the settlement. And since they have not appeared, Your Lordship can see the section 22, subsection 8.
Yes, read.
Where the parties fail to reach at an agreement.
Yes.
Under subsection 7, the permanent Lok Adalat shall, if the dispute does not relate to any offence, decide the dispute.
Yes, not all the dispute.
Not all the dispute. If it is not related to an offence,
we give this legal services authorities. Permanent Lok Adalat jurisdiction extends to the public utility service.
Public utility service. Public utility service has been defined.
Also defined.
Yes, ma'am. That has been defined under section 22A.
Yes.
AB. What is public service utility?
So we got the book. Yes.
That is includes transport service of the carriage of passengers or goods by air, road or water. Second, postal, telegraph or telephone service. Third, supply of power, right or water to the public by any establishment. Fourth, system of public conservancy or sanitation.
Yes.
Service in hospital or dispensary. Insurance service, housing and estate. We are coming under that. The housing and estate. That is subpara 8. Just 7.
Have you shown this to the single judge?
Yes, ma'am. We have shown it. We have shown it, and in spite of repeated notice, that did not appear. And we have heard that in paragraph 15 of the appeal memo.
The rules.
At your lordship, you can see this. But sorry, I have one copy.
That's all right. Yes.
So jurisdiction 10 lakhs, how much will the property?
There's amended to 25 lakhs. Come to the.
You can see 22 C.
Absolutely. All right.
Let's 22 C. Cognizance of cases by permanent local adalat. Any party to a dispute may, before the dispute is brought before any court, make an application to permanent local adalat.
That's all. It is a pre-litigation. That is why it has been named as a pre-litigation forum.
Yes, ma'am. And the right of the adjudication has been given to the permanent
We have
local
to see also the notification because all the public utility services may not be under the jurisdiction of the permanent.
Yes, so therefore it has been defined.
Definition can be go when a permanent look adalat will be set up. In which matter, in which public utility services this jurisdiction will be applied, that has to be mentioned in the notification. It is not that in the all automatically.
Yes, there are lots of
yes, that is one thing. And how the single judge had dealt with this issue.
That the single judge has dealt with the issue only by saying, since they have not participated in the possible terms of settlement, so therefore the permanent local adalat cannot.
That is not local adalat under section 19 or 21. It is 22 is a special kind of local adalat.
Yes, madam. Always some kind of local adalat. That is the only finding that the learned single judge has did.
Heard Mr. N.K. Sahul and Kansai appealing to the appellant. Friends, by means of this intercourt appeal, the order dated 16/3/2022, passed by Learned Single Judge in WPC number 6712 of 2021, has been challenged on the ground that Learned Single Judge has observed wrongly regarding the jurisdiction of the permanent local adalat in absence of consensus. Stop. Admit to be heard in merit, issue notice returnable on 29th of September 29th No, 27th of September 2023. Steps for service on the. How many respondents are there?
Let the that
Case registered for service of notice on respondents number 1 only, as we are not inclined to issue any notice on the respondent number 2, being the statutory adjudicating body. Steps be taken by registered postal ID. Return this.
the 5 is also same arising out of the same order. Arising out of the same order because we have filed because the permanent local adalat did not grant the interest. So therefore we have filed one writ petition and the challenging the award they have filed their own.
The next also the same thing.
Next also same.
Similar order.
That is concerned to the interest.
All right, whatever. That is the issue is the same. The
Issue is the same.
permanent local adalat doesn't have the jurisdiction to decide the matter.
Issue is the same.
All right, same.
Item number 6.
Yes.
My lord, item number 6, kindly grant us 2 weeks time
Why?
on behalf of Senior Counsel Mr. P.K. Rath.
No, why? Last occasion also adjournment was granted. Today also you are seeking adjournment. Even this earlier 2 occasions adjournment was granted liberally to you. Why the third occasion we grant you adjournment?
My senior has instructed to seek adjournment.
Your senior may instruct you because you are also a lawyer. You are making your submission before the court of law. Tell us the first one, 1/5/2023. Then the matter was listed on 31/7/2023. On all those occasions, we granted you the adjournment. Now, why on the third occasion we dismiss this appeal for non-prosecution? Because absence of senior counsel doesn't anyway deter the court proceeding. The persons on record, they should take the responsibility because they are holding the brief. Do you know anything about the case? Do you know anything about the case? You are not on record also? You are on record? Have you filed the Vukalatnama? Huh?
What is your name?
Aroma Raut.
What is your name?
Aroma Raut.
Aruna?
Raut. Yes.
Yes. The whole power.
So you do not know about the case?
Let her read and come back.
We will take up the matter day after tomorrow. Day after tomorrow is a Friday, no? Huh?
Right.
Monday. And we will not allow your senior to, because you are granting only adjournment, looking at your press, the face. Otherwise, you will not grant any adjournment. So you have to appear on Sunday. We will not allow your senior to appear before us.
Have you understood? You get prepared and come.
Yes, ma'am.
Take guidance of your senior, get prepared and come and argue the case on Monday. All right?
Yes, ma'am.
Yes, my lord, you say boldly, yes, I will do it.
Yes, my lord.
Yes. List on Monday on the prayer of MSK Raut and Council appearing to the appellant. This is the third occasion that we are making accommodation for the appellant. No further accommodation will be made on the next date. Mr. D.K. Mohantil and Council and Regional Government Advocate is appeared for the respondent. You are appearing there?
Yes, madam.
For respondent number?
Private respondents.
You are
Excluding the private respondents. I'm just pressing.
Are you sure you are appearing for the private respondent?
No, excluding the private respondent.
There is any other respondent excluding the private respondent here. Appearing for the respondents number 33, 34, 34 and 35.
33 to
35.
35.
Okay. Next.
Item number 7.
Yes, ma'am.
Item 7.
7 why not taken off 2 p.m.
Why?
7
Why 2 p.m.?
Mr. Senior counsel is busy in another court proceeding.
Other cases are there at 2 p.m. It may be adjourned to any other day.
Same day, that same senior.
Monday. Any objection?
I'm appealing for the respondent.
Have you any objection? We are asking.
No, ma'am.
Fixing on Monday next.
No, my lord, that's fine.
All right.
Yes, senior will come.
Yes. As requested, Mr. P.K. Raut, Senior Counsel, with the matter will be listed on Monday. Give the date only, not Monday, right? Monday. The date.
Gagan Bihari Singh.
You are Mr. Singh.
My lord.
The request of Mr. Gagan Bihari Singh. Okay. Mr. S.S. Tripathi and Counsel appeals for the respondent number 1 when the matter is taken up.
Item number 8.
Make user lordship. Selection of reporters to the Odisha Legislative Assembly.
Yes.
The selection process was made. During the selection process, it was the mandate of that there would be a unanimous opinion. Only on unanimous opinion the selection would be made. But despite that, there was a dissent note. Now, very mysteriously, the dissent note disappeared from the records. If your lordships will kindly see the counter affidavit filed by the Legislative Assembly, which is at Annexure 3, page 61.
Of the writ appeal?
Of the writ appeal, yes, sir.
My lord, before my learned senior proceeds, I am having it. Let him serve a copy of it to me so that I can give me a reply. Let it come next week. Because another writ appeal has already been dismissed as infructuous and a common order was passed. And the second round litigation is pending, which will come up this week. So I only pray, before he advances any further arguments, that let him give him a copy, let it come next week on next Tuesday or Wednesday, if your lordship permits.
Yes, sir. It is item number
8 by 8.
My selection has been challenged, my lord, in this writ application by a failed candidate.
That's such adverbs. Because it is your father who manipulated the entire process. He is the deputy secretary of the.
He's the part of the
we for only responding number 2.
2 and 3, my lord.
All right, Mr. Subrat Mishra, when counsel by filing caveat has appeared for the response number 2 and 3. We request, who is it?
No, one is to be noticed because they are.
I am not issuing the notice right now because no order has been passed regarding admission as yet.
Yes.
Only I just enabled Mr. to get the copy as a caveat. I would request Mr.
My lord, in this case,
who is appearing?
Mr. Dev Rai.
Oh, Mr. You are on record.
He is on record.
What opinion?
Mr. S.D. Roy and counsel appearing for the appellant shall supply a copy of the memorandum of appeal along with the copy of the IA number 3501 of 2023. In the course of the day, let the matter be listed on Monday next.
Some personality.
29.
29. Okay.
29th I have some difficulty. Let it be 30th, madam.
30th, my lord. I have no objection.
Mr. You are appearing for the Orissa.
No, I am not appearing for Orissa Legislative Assembly.
No, because we have not noticed, we will not record because you have filed the caveat.
No.
Stop. Caveat stand discharge. The caveat number is
123 or 23.
123 or 23 stands discharged.
No.
Yes.
Item 9.
Yes, item 9.
No, please, Your Lordship.
Yes.
No, here the appellant has challenged the order of the learned singers, while the learned singers without adjudicating the matter on merit, my lord, are disposed of by relating the matter to the due, my lord. Lordship, on last occasion, Lordship directed my learned to obtain instruction, we have also filed the affidavit, my lord. When the affidavit, Lordship may only come to page 6, my lord. Affidavit filed by the state, my lord.
Yes.
Look, page 5, last para, my lord. That on 27/7/2023, the learned single judge of this Honorable High Court in WPC number such and such passed a judgment directing the state government to prepare a uniform policy with regard to preparation of gradation list of elementary cadre teachers within a period of 2 weeks. The learned single judge has further directed that the benefit of promotion of elementary cadre teachers shall be extended only after the policy is finalized and final gradation list is prepared. If such direction are implemented, the state government has been directed not to grant any promotion to the elementary cadre teachers. Lordship, let them come to para 17, my lord. That after such uniform policy is issued, the persons who have not been promoted as well as the persons who have already been promoted shall be subject to verification, re-verification in order to ensure that they satisfy the eligibility criteria recruitment for promotion. Now, my lord, my prayer before Lordship is, but until this resolution is prepared by the state government, I shall not be reverted.
Well, that is my averment in the counter affidavit, that we will not take any, we are not taking any steps for anyone's reversion until that uniform policy is disclosed in this light, my lord.
Observe, because they are verification only after
Only after the policy is closed. They have to, my lord, subsequent call the back.
verification, if you found you are not
Yes, my lord, yes.
promoted, that all right. But Mr. K. Swine and counsel appearing for the appellant, and Mr. Pranav Behral and Division Standing Counsel appearing for the respondents. All right. This writ appeal arises out of the judgment and order dated 25/7/2023 passed by the single judge in WPC number 22911 of 2023, by which it has been observed that the petition has already joined in the promotional post, but the petition is aggrieved with the communication issued by the opposite party number 2 under Annexure 6, wherein request has been made to BUP opposite party number 4 to re-verify the proposal with regard to such promotion, and on such re-verification, if it is found the petition has been given promotion, violating the stipulation contained in the OEE Cadre Rules 1997, then the concerned employee be reverted immediately. The basis of the filing this writ appeal is the apprehension that the petitioner may be reverted forthwith, even before the policy is adopted. Stop. What is that recording has been made in their counter affidavit?
Yes, my lord. That is my case 6, my lord. Case 6.
Stop.
I have also annexed the judgment of the learned single judge at page 12.
Stop. The respondent number 2 has filed the counter affidavit in this writ appeal on 19th August 2023 by asserting inter alia as follows. There are 15. There are 16. There are 18. So, Mr. Behral and counsel has categorically stated that the appellant has no reason to apprehend that he will be reverted without the verification carried out in terms of the order of the learned single judge dated 27/7/2023, passed in WPC's number 21773 of 3 and 22159 of 2023. So, Mr. Swine has immediately submitted that, having recorded that observation, this appeal can be disposed of. Accordingly, dispose of this writ appeal, observing that before the uniform policy and the verification based thereon is completed, petitioner shall not be reverted, even if it is found that his promotion was not regular.
Yes, great.
All right. There shall be no arrest to cost.
Great, my lord. Item number 11.
The appellant is challenging the impugned order passed on 14th August 2023 by the Honorable Civil Service Double Piece number 25,996 2023 on the ground that the order passed in the repetition has not been considered in the light of the passed in Double Piece number 20,334 of 2022.
What is the right on the land that you are occupying? What is your right?
During this period, internal period of operation of this order, the respondent number 4 has issued a notice to evict the appellant.
Yes.
I is there to stay the operation of the order.
What on the what ground? What ground? You are occupying a government land.
Because liberty has not been given to the appellant to make an application for the
Liberty.
What liberty?
liberty has been given in the order.
You have given liberty by the state issuing you the notice to respond, and you have straight away come to the court.
On 25th of August.
Yes. Yes. This order was passed on 23rd of June 2023.
14th August.
This order was passed, impugned order?
14th August.
14th August. Yes.
Notice at Annexure 2, man.
So you had been given the 10 days time.
Yes, madam. The liberty has been.
You have also filed a writ petition.
Yes, that is the main.
That is Annexure 3, I think.
Yes, madam.
Have you filed that writ petition? Your petitioner is that.
Party appellant has filed.
Which appellant?
Another appellant is, another petitioner has filed.
No, in this case, there only one petitioner, Ashish Kumar Naik.
Yes, my lord. Another.
No. Whether the Ashish Kumar Naik is any relation of Sita Naik, who is the writ petitioner of 20334 of 2020?
Adjacent plots, my lord. There is a proposal for.
Same notice, same market complex.
Market is going to be market complex.
So?
The appellant has not been allocated shop. Liberty has not been given.
No. You are there for how many days or years? Are you in the possession of that land?
Yes, ma'am.
For how many days or months, years?
20 years.
You do not cross the 30 years for getting the allotment on the basis of the encroachment. So?
Yes, my father was there before me.
Mr. Mohanty?
Yes, madam.
We are not interfering in the order. We will only say they will make an application. You just find out whether they can be allotted some other alternative land or not.
My lord, the most important is the order passed in the earlier case, which is annexed as Annexure 3, page 24.
Yes.
Similarly placed persons. And he is one of them, like Sita Naik and others in that combined case. And your lordship may kindly see page 26.
I have seen that order.
Having considered the counter affidavit of opposite partner 2 and 3 and the fact that there is no assurance to the petitioner for being provided stalls in the proposed new market complex, the court is of the considered view that the grievance of the petitioner concerned have been well addressed and therefore they should be directed to vacate the scheduled land. So affidavit was filed that we cannot give any assurance in the new market complex. They will be
given any, all these similarly placed
How
persons.
many persons are there?
At least in this case, there are three, and he is.
It is from the very beginning, it is a marketplace.
It is dilapidated. Now we are making a new construction, and the
You will not give them any.
we are not giving any assurance that you will be provided, because in that way, when the market complex will be constructed, then rooms will be allotted on auction basis. That is the government's decision. So he can participate, he can apply, but that priority or preferential right, that assurance perhaps not given to the other petitioners of similarly placed persons.
No, all right, we understand. You are dispossessing that there is a continuing market. You are the state. We expect something more from you, that at least some accommodation should be made for them in the marketplace.
My lord, page para 10 may be seen.
You fix the rate, all right. You fix a reserve rate. They will pay that. But how can you just completely evict them without giving any sort of livelihood option? It is not a question of the government policy. We are also looking
No, that honorable judge has given in that case some liberty. I'm just placing.
We are not bound by that order.
No. I'm just placing for your lord's reference. Page 10. Hey, para 10. In the result, the petition stands disposed of with a direction to the petitioners to vacate the scheduled lands within 20 days from today and hand over the possession of it to opposite party number 4 in order to facilitate early construction of the proposed supermarket complex, keeping in view of the assurance of the opposite party number 2 and 3 in making provisions of stalls for them in the said complex.
That's all right. Similar order.
Similar. And no, my lord may kindly see, in the impugned order, the court has taken care of, the honorable single judge has taken care of this observation. Page 18 para 8.
No, that is also that the facility early construction of the proposed supermarket complex, keeping in view of the assurance of the opposite party number 2 and 3.
That is also applicable to him.
In making provisions of stall for them in the said complex.
Some stalls will be given. And your lordship may kindly have a glance at para 8, page 18. The land is not at the
I will be just quoting this para 10. I will dispose of this later.
No, that is there. Just 1 minute, my lord.
You are referring this?
I am referring the impugned order. At page 18.
You say that those persons are also similarly situated.
Persons, and whatever liberty was granted to them, same liberty is also granted to the petitioner.
Quote 8 and say the same benefit should be granted to the present appellant. Is it not clear to you?
Yes, and that has been given.
We are not even going to change a single comma from that quote.
Furthermore, liberty is granted to the petitioner, that is the present appellant, to make an application to opposite party number 5 seeking similarly relief as allowed in WPC number so and so. I am just placing page 18.
No, yes, we understand the page.
That is all. I am not.
We will be quoting the paragraph 10 from page 26.
And para 8 of the impugned order.
No, 8 will not going because that is the proposed new complex. There is a factual aspect.
Yes, my lord.
It's already will say the similar benefit.
What I beg to submit that they have no prejudice because we are going to.
I am saying that just simply.
Yes. That
notice to
both the rights. The market will be constructed here. In para 10, in the decision that in section 3, they have stated that you will be given one shop. That is the assurance.
No assurance has been given now.
That is.
Now we are quoting that similar treatment will be given to you.
Yes, ma'am.
Right? Okay.
Yes.
You are Mr.
K.C. Shaw.
K.C.
Shaw.
Heard Mr. K.C. Shaul and counsel agreeing with the appellant. And Mr. D.K. Mohanty Lanet, additional government advocate, appearing for the opposite parties. Respondents 1 to 3, 4, 1 to 3 and 4. Also the 3, 4 and 5.
No, my lord. Actually, 5 is to be appear. Anyway.
No, 5 is a government officer, Mr. Mohanty.
No, RMC, Secretary RMC Dungurpalli.
RMC, the SDMs are usually made the secretary.
Yes.
4 and 5.
Oh, listen, 4 and 5. So, by means of this intercourt appeal, the order dated 14/8/2023 was delivered in WPC number 759,996 of 2023 has been challenged by the said order under the same judge has directed that the petitioner shall vacate the scheduled plot within 10 days from the date of order and hand over the possession
To the RMC.
to the opposite party number 5 immediately. Stop. Till the time the land is vacated, there shall not be any coercive action against the appellant herein. Liberty was also granted to the petitioner to make an application to the opposite party number 5, seeking similar relief as allowed in WPC number 20334 of 2022. Stop. Mr. Sahul and Council has drawn our attention to the order dated 23/6/2023, passed in a series of writ petition, including Sita Naik versus State of Orissa and other, within the WPC number 20334 of 2022, where the land single judge has passed the following order. Court para 7 at page 36. Stop. Mr. Mohanty has generously submitted that the appellant will be treated similarly to the petitioners of that series of petitions.
Yes.
Stop. In view of the statement, we direct that the petitioner shall vacate the scheduled land.
The 10 days is over, right? Yes, your lordship can extend it.
Within 20 days from today and hand over the position to the opposite party number 4. To the opposite party number 4.
5.
Opposite party number 4 and 5 both.
4 and 5. Tahsildar and RMC secretary.
4 and 5 in order to facilitate early construction of the proposed supermarket complex, keeping in view of the assurance of the opposite party number 2 and 3 in making provisions of stall for the petitioner, persons like the petitioner in the said complex. In terms of the above, this appeal stands disposed of. Urgent certified copy.
My lord, what has happened? All have vacated, only there. So
20 days I have given.
20 days.
20 days you vacate it. Otherwise you will not get that benefit.
My lord, the petitioner can be directed to produce this order before the authority for.
No, we are giving the order to you.
Yes, I will.
Stop. It is also made clear that if within 20 days the position is not vacated, the Tahsildar may take the coercive actions to vacate the land. A free copy of this order is applied to Mr. Mohanty and Council forthwith. All right.
Item 12.
Obliged. No, Lordship. It will challenge the motion issued by the collector for the establishment of the Lordship in lubricant detail outlay the Lordship. Where the page number 5 has established a detail outlet in government land Lordship. Partly Lordship private land and partly Lordship government land Lordship.
Mr. Mohanty, how that can happen in a government land? You are allowing fortification?
What I find, personally, I have verified. He is saying that partly government land, partly not that full government. So that is a disputed. I have to seek instruction whether any government land is encroached or not. So your lordship may issue notice to the private respondent also.
You are Mr. Pandit.
Yes, Your Lordship.
Mr. P.P.K. Pandit and Council appears for the petitioner. Allegation that has been made in this public interest litigation is that one IMFL license license has not been issued as yet, I think.
Already issued, I think.
Already issued
Already issued.
In favor of the opposite party number 6.
That is since long. Issued 1 year, last 1 year.
25/7/22.
22. Already 1 year completed.
Stop. It has been further alleged that one no objection certificate has been issued in favor of the opposite party number 6 on 27/5/2022, Annexure 1 to this petition. So, it is a petition has alleged that part of the government land has been used for constructing the shop where the said licensee will run the INFL retail shop. So, issue notice returnable on 4th of August 2023. Petitioner shall take steps for service of notice on opposite parties, number 5, 6, 7, and 8. Registered post with AD as Mr. D.K. Mohanty, London Government Advocate, appears and waives notice for the opposite parties number 2, 3, and 4. Stop.
1 also.
1, 2, 3, and 4. Stop. Steps on the opposite party number 5 and 6, 5, 6, 7, and shall be taken within 3 working days from today.
4 weeks time may be granted to file counter. We'll file a counter, regular counter.
We have given 4th October. 4th October. It is not more than 4 weeks.
Yes. Sorry, I'm actually, I couldn't hear.
Item 13. Lots, some defects have been pointed out. Maybe allowed some time to remove the defect.
Well, let the matter be listed on 11th of September 2023 at the request. Here, Mr. Raut.
My lord.
Yes, Mr. Niranjan Raut, Learned Counsel, appearing for the petitioner. So, meanwhile, the petitioner shall remove the defects as identified by the registry. There is no further accommodation in the matter.
I am appealing for the
Mr. D.K. Mohanty, Learned Additional Government Advocate, has appeared for the opposite parties on advance notice.
Item 14.
This is a public interest litigation. The land allotted for the purpose of the bus stand is being utilized for the other purposes. There is a residential there is a commercial complex. Your lordship come to page 11.
Yes, what is happening, Mr. Mohanty?
I have to take instruction from the collector what is, whether the allegations are.
Interest of expression already invited.
You are Mr. Rath. Mr. Karunakar Rath, Learned Counsel, appearing to the petition. And serious allegation has been raised against the state opposite parties for allowing the land which has been allocated for the construction of the bus stand for other commercial use without any authority. Stop. Even part of that land has been being utilized for the residential apartments. So, issue notice returnable on 4th of October 2023. Since Mr. D. Mohanty, Learned Counsel, appears and waives notice for the opposite parties number 1, 2, 3, 4, and all the opposite parties, no formal notice is called for.
I use their
what
I in public interest litigation,
then they are going to construct arranging on the materials. The lordship will status to be maintained.
No, not status quo. Let them construct. We'll order for removal of the all structures. Yes. Don't worry.
Yes.
Item 15.
Date will be fixed.
4th October.
Item 15.
yeah, please.
Yes.
Here this is a PIL millets. And the limited grievance for millets lordship is, though the section 33 and 34 mandates that the 4% reservations of the post in all the government organization meant for that should be reserved for the persons with disability. And accordingly, a committee is to be constituted for identification of the job.
Yes.
That section 33 also kindly just section 33 I'm reading this.
This-
For office convenience, section 33 of the Acts. That is
He acts in 2013.
persons with disability Acts.
He has brought the book.
Yeah, they will.
You have.
I'm relying on 33 and 34.
All right.
33
Please, you make your submission. Okay.
Let's solve. 33 only for one. That is, she said that a committee has to be constituted section 33 for identification of the post. 33 is there.
Yes, yes.
And that act was enacted in the year 2016 act. And now the government has been pleased to constitute a committee in the year 2022 annexed to, let's say, kindly see page 40. The committee was constituted in the year 22 after 5 years. And as of date, no post has been identified by the committee. Thereby, there is no reservation for the persons with disabilities.
Who is appealing to the state?
Yes.
Mr. Kuntia, even you are not following the statutory mandates. Mere committee, but we are granting you 3 months time for identification of the post. You are disposing this public interest litigation. All right.
Yes, and dispose of saying that, and the consequential the actions should be taken because the government of India have given various circulars, the instructions. The government time and said to fill up the existing vacancy and backlog vacancy. That has not been done for last 5 years. Nobody is getting the benefits. Irrespective of statutory provision.
D.K. Mahapatra and Council appealing for the petitioner. We have also heard Mr. M.K. Kuntil and additional government advocate. By means of this public interest litigation, the petitioner has raised a serious question of public interest to the effect that the state government, that the government of Orissa, even though constituted the committee, what is the constitution of the committee?
Page 40.
Annexure?
Annexure 2.
Constituted committee by the memorandum
Notification. Dated
dated 24/5/2022
in terms of section 33.
But till now, the committee has not identified the post for reservation for the persons with benchmark or other disabilities. Stop. Section 33 of the Rights of the Persons with Disabilities Act 2016 provides that the state government shall constitute an expert committee with representation of the persons with the benchmark disabilities for identification of such post and to undertake the periodic review of the identified post at an interval not exceeding 3 years. So the purpose of constituting that committee is to carry out the mandate of the said Act of
34, section 34 of the Act.
As provided under Section 34, that every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which, 1% each shall be reserved for the persons with benchmark disability under clauses within first bracket small a, comma, within first bracket small b and small c, and 1% for persons with the benchmark disabilities under clauses D and E, namely go down A, blindness and low visions, B, deaf and hard of hearing, C, locomotor disability, including cerebral palsy, leprosy, cured, dwarfism, acid attack victims, and muscular dystrophy. D, autism, intellectual disability, specific learning disability, and mental illness. E, multiple disabilities from amongst person under clause A to D, including blindness in the post identified for each disabilities, provided that Reservation and promotion shall be in accordance with the such instructions as will be issued by the appropriate government from time to time. So, having regard to this section 34 of the Reservation Act, we direct the state government to publish the roster in each department showing the 4% post reserved for the physically persons with the disability in terms of the above provision as referred by us. And the entire exercise shall be completed within a period of 3 months from today. So after the roster is published, the vacancies that will be available for being filled up by the persons with disabilities shall be filled within next 6 months without fail. In terms of the above, this application stands disposed of. Yes.
A copy of that order be supplied so that I
A
can
copy of this order be supplied to this and take from here. So government April 24th.
Item 16, may I please let's see. My lord, in this case, challenge the validity of Rule 4, Groups B, C, and D group postal law. Similar order plus a past matter. Other matter will be fixed for hearing 27/9/2023, my lord.
All right.
Other matter, the counter already filed one, but still directed to serve the extra copy, my lord. File the rejoinder, my lord.
Heard Mr. N.C. Raut and counsel appearing for the petition. The date is 27/9.
27/9, my lord.
Just to copy this, huh? Oh, no, extra copy is required?
not required.
All right. So the 6, you don't, supposing the 6. Also passing the interim order in the similar line.
Yes.
Have you filed interlocutory application? This is
Yes,
for
madam.
stay. This is for stay. You have asked for stay in this matter. All right. Yes.
Subject to outcome.
That is there.
Yes.
That is the only stay order. So the same stay order. Okay.
Oh, bless.
Item 17.
Yes, Mr. Tripathi.
May I please?
Any information?
No, my lord.
My lord, I'm appearing for the set. My lord, I'm
Part of the series, Mr. Pari?
No.
No. In one piece of paper is here showing that the 25 cases are related to this matter.
No.
So you have removed the defects
No, my lord, defects have not been removed.
because the order dated 12/4/2023.
Yes, ma'am.
Have you seen that order?
12/5/2023.
12/4/2023. Put up this matter before any other bench of which one of us, Mr. M.S. Ramon, is not a member. And so you do say these other matters are not related?
In fact, initially, my lord, there was the bonds that has been reflected in the order dated 12/5. Kindly see the order dated 12/5. We have stated that this is covered by that decision, my lord. In the case of State of Odisha versus Gitasri Industries, in that there was a batch, my lord. In fact, there the question was decided against the department,
So if that ratio is taken in this case, it will be, my lord, it has to be answered in favor of the department, because there in that case, this honorable court held that Chuni is not cattle feed, my lord.
Okay.
So here, my lord, it's the contention of the RCC is that bran, which is similar to Chuni, my lord, which has been sold as cattle feed. So it's that, so he says bran is included in the cattle feed. So if my lord takes that batch of matters, then that has already been decided that Chuni is not cattle feed. So if that ratio is borrowed here, then my lord, this question has to be, is to be answered in favor of the department.
Are you appearing
Opposite department.
for the department?
For the RCC, my lord.
For the SCC, are you appearing?
Next week. On behalf of
If that decision is actually approved by us, then the matter ends here only.
Yes, ma'am. Yes.
So we'll take up the matter on Monday, come with full preparation. List on Monday. Mr. S.S. Patil and Council has stated that this decision is squarely covered by decision of this court in State of Orissa versus Messrs. Geetosri Industries, column 2, 2022, within bracket capital Roman 2, close the bracket ILF, dash CUT 833. So what we request, what is your good name, sir?
SK Sahu. May Ashok, on behalf of Ashok Mahandri, SK Sahu.
SK Sahu. And council is appeared for the SSC opposite party. All right.
Item 20.
20.
My lord, here the notice has been issued, my lord, on the last date.
None appears, notice has been issued.
None appears, my lord. Postal tracking is there.
Yeah, this matter also a similar matter.
But here the issue relates to levy of penalty under section 42 of the OVAT Act. Now, your lordship in many judgments have held that this penalty, as per the language of section 42, is automatic. Once the tax has to be held to be payable, or penalty is automatic, there is no requirement of mainstream, my lord. So this issue will also be covered by those, my lord, judgments.
What happened to the notice has been issued?
Yes, my lord. On the last day, notice issued. Noting shows the postal tracking is.
That is the notice shows that it has been served according to the postal tracking report.
Lord. Then, madam, make that question.
That postal AD of the admission from citizens also received, but no one appeared on behalf of the office. Postal tracking report, as citizens may receive. So the report is 1 and 2 is complete. Only 1 and 2 are the opposite parties, I think.
Yes.
So they have received it.
In my lord, I pray the question of law may be framed and let them.
Okay.
So with that,
what is your question of law?
Page 17, my lord.
Or Mr. S.S. Pari, Grand Council, Western Standing Council, Commercial Tax and GST. It is for the revision petitioner. This revision petition arises from the order dated 29/2/2016, passed by the Orissa State Tax Tribunal in second appeal number 40, then bracket number 5, close the bracket of 2013 and 14.
Tribunal's order is at page 31, madam. Annexa 4.
Yes. By this said order, the tribunal has.
If your lordship could see page 34, the last two lines. page 34, the last two lines.
Observe that the departmental authorities completed the self-assessment procedure under section 39 of the OBT Act right at the beginning. Then the fault of the dealer could have been informed. The question of imposition of present penalty would have been a remote possibility. Stop. It has been further observed that the dealer, since the dealer is not found to be involved in clandestine transaction, the imposition of the penalty to the tune of rupees 2,46,372.00 under section 42, Amendment 5 of the OVAT Act is now waived. So the assessment tax is reduced to rupees 1,23,186.00, which the dealer is now required to pay. So being aggrieved by that order, the present revision petition has been filed with the revenue to admit this revision petition on the following substantial question of law. Page 17, no?
Yes, my lord. He filed page 18, question number 4. That sole question will suffice, my lord. Page 18, question number 4. In fact, all these questions relates to that, my lord. Only 42.
All right. The following substantial question of law. Whether the Orissa Syntax Tribunal erred by failing to take into consideration the expression quote dash quote shall be imposed by you a penalty unquote while deciding imposition of penalty under section 42(5) of the Orissa Value-Added Tax Act 2004 by the assessing authority as authority. Stop. Question mark. This is the only question.
This penalty is the only question.
Issue notice returnable on.
No, notice served. Already served.
Notice served?
Yes, ma'am.
No, all right. Yes, all right. It may be noted that despite notice being served on the opposite parties, they have not turned up as yet. So let the revision petition be listed for hearing on October 3rd October last, huh? After the Puja vacation, give that vote. 16th of October. Sorry. 30th.
Otherwise, it's a covered matter by your lordship's decision.
All right, then some other day, then September. You want in September?
Any short date so that it will be discussed.
All right. 14th or 13th of September, no? 13th of September.
There are two IAs for one IA for dispensing, IA 45 of 2016, where I prayed for dispensing.
Notice has been already issued, so automatically now it has to be dispensed with. Have you filed the certified copy?
1, 2, 3 are not impugned herein. It is only the tribunal's order, which is Annexure 4. So I prayed for dispensing with Annexure 1, 2, 3.
All right. Third, Mr. S.S. Pari, Standing Counsel for Commercial Tax and GST, appearing to the applicant. There is an application for dispensing the filing of the certified copy of the annexures 1, 2, and 3 of the SL3 of the revision petition. Mr. Pari has pointed out that attested photocopy of those documents have been enclosed with the revision petition. So, having scrutinized that those documents are part of the revision petition, we dispense with the filing of the certified copy of these annexures 1, 2, and 3 of this text petition. Accordingly, this petition is stands allowed and disposed of. So there is a state petition.
Yes, my lord. IA 44.
This case number 44 of 2016. Heard says in such. It is a 2016 matter.
Yes, my lord. If my lord is fixing a short date, then my lord, I may not phrase this.
Alright. Heard says in such. There is an application for staying the further operation of the impugned order dated 29 to 2016. Answer 4 to this related to the revision petition. So we have scrutinized the impugned order dated 29 to I think. 29 to is the impugned, 29 to 2016. And prima facie we find that the applicant has made out a case that they have a good case for the revision. In view of the above, we did a further application of the order dated 29 to 2016. So we grant the liberty to the opposite parties to approach this court for alteration, modification, or cancellation of this order. So in terms of the above, this petition stands disposed of. All right. Next.
Item 21.
Yes.
Here also, my lord has issued a notice on the last day.
Notice is not been
No, my lord, beg pardon. Not issued.
Heard Mr. Eros Pari. The similar kind of issue. What is the substantial question of law?
My lord, it's page 9, my lord. Whether on the facts and circumstances of the case, the tribunal is justified in confirming the view expressed by the first appellate authority that though zinc dross is nothing but zinc, yet the same would not fall within the scope of entry 11 of part 1 of schedule appended to the Odisha Entry Tax Act, namely seats, rods, etc. of non-ferrous metal including aluminium.
That is the only question.
That is the only question, madam.
So by means of this revision petition, the review has challenged the order dated 36 to 2016 for the Odisha Celtics Tribunal in second appeal number. Order dated 36 to 2016. First and second appeal number 200 within bracket 80 close the bracket end of 2012 and 13. By dismissing the appeal filed by the revenue against the order dated 3/12/2012 filed by the first appellate authority, the Deputy Commissioner of Sale Tax, Sundarban Range, Rourkela. The first appeal number AA Roman 5 1780 of 2011 and 12. In respect of the assessment order dated 39/2020. So by the said order, what is the this order is where is that order? Appellate court's order? D12 may be annexed it.
Yes, my lord, that's at page,
by the
page
said
17.
order, yes, I got it. By the said order, the first appellate authority
Has directed.
has allowed.
Yes.
The appeal
directed for refund of that amount.
Appeal by directing the refund of the
That's 13,84,856.
13,84,856 on observing
Page 20, last paragraph.
20.
Malad is saying about first appellate order.
Yes.
Yes, page 20, last paragraph. That's the finding, Malad. In view of the foregoing observations, it can be concluded that the learned assessing officer has fallen into error by applying the entry number 11 of part 1 of the schedule appended to the Entry Tax Act for levy of entry tax on zinc dross.
By setting aside the finding of the assessing officer, assessing authority, and observing that the assessing officer has erred by applying the entry number 11 part 1 of the schedule amendment to the OET Act for levy of entry tax on zinc dross. So, according to the first appellate authority, there is no legal bar under the OET Act to file a revised return for claiming the refund of the entry tax paid on purchase of these unscheduled goods under wrong notion of law. The denial of wrong notion of law. This much, I think, this observation. All right.
Yes, ma'am.
So admit this petition on the following substantial question of law.
Page 9.
Court over just whether on the facts and in the circumstances of the case, the tribunal is justified in confirming the view expressed with first appellate authority that though zinc quote unquote dross is nothing but zinc, yet the same would not fall within the scope of entry 11 of part 1 of the schedule appended to the Orissa Entry Tax Act 1999, namely sheets, rods, etc. of non-ferrous metal, including aluminium. Court issue notice. Notice has been issued now.
No, madam.
Issue notice on the sole opposite party. Returnable on 27th of September 2023. Steps to service of notice by the registered court shall be taken on the opposite party within 3 working days from today. The defects as identified with the registry shall be removed within a week from today.
Item 22.
Registration. So next case 103 of 2016. Administration search is an application for staying the operation of the MP order dated 30/6/2016. So issue notice returnable on the same date. Meanwhile, operation of the said order dated 30/6/2016 shall remain suspended. Steps for service be taken within 3 working days from today by registered post with AD. Here also the dispensation application.
Yes,
the same way dispensation application earlier, this application also dispensed with. Here will be on the annexation 1 and 2. Here is 1 to 3. 1 to 2. Just see the first act. All right. Next.
22.
On behalf of Mr. Chandra, a defense report within the wood matter.
You are Mr. Pandar.
I am Mr. Mohan, M.K. Mohan.
You are not there?
No, my name is not there. On behalf of Mr.
The request of Mr. Mohan. The council appear on instruction of Mr. A.C. Behral and council for the petitioner, let the matter be listed on 11th of September. In the meanwhile, the defects as identified by the registry shall be removed.
Item 23.
Item 23, on the last occasion, we have taken time to take instruction whether this opposite party dealer has gone in insolvency or not. What is the stage of that insolvency proceeding?
Yes.
I have taken instruction. In fact, during the insolvency proceeding, another concern has taken over this form.
So,
I'll file application for substitution, my lord.
the request of Mr. S.S. Paril and Additional Standing Council for Commercial Tax and Registry. Let the matter be listed on 27th of September 2023. Meanwhile, necessary steps as required to be taken for taking over of the these opposite parties shall be taken. Stop.
Next, item 24.
Please, my lord. My lord, I will pray to remove the defects, my lord. Ignore the defects because, my lord, this case was earlier already heard ignoring the defects, my lord. And on 31/10/2021, this was disposed of. Subsequently, on the review application, the case has been restored. And on 14/11/22, I have, as per direction of this honorable court, I have already served the copy of the writ appeal, my lord.
Writ appeal. I have instruction to appear. I don't know on whom you
Served the copy. 24.
I have the instructions to appear. I was appearing in the writ petition.
This is the, my lord,
Along with my associate.
copy of the receipt.
By whom? He is saying that he is appearing.
He was appearing. I was appearing in the writ petition. I was the petitioner in the writ petition.
To whom you have served the copy?
My lord, the name is there. I'm saying.
No.
Kamarin Sattar. Karmin Sattar, my lord. Is in order dated 20/10/2022. His name has been reflected. He was present in the court, my lord.
20/10/2022.
In that order, its name of the council has been reflected. I will serve another copy, your lordship.
So I will serve another copy.
I will serve, my lord.
Because there is no reflection in the order.
My lord. In the review petition, my lord. He was appearing in the review petition. I will serve an yes, my lord.
Review petition also none is appearing.
No. When he appeared, the not filed Binama, but at the time of hearing, he was present and he submitted that he was appearing and his name has been reflected. I will serve another copy, my lord. I will serve.
All right. You are Mr. Bahadur.
My lord.
Third, Mr. Shamalan Bahadur, counsel appearing to the appellant. Bahadur has stated that in terms of the order dated 20/10/2022, this appeal has been restored to its original file. So today, you are Mr. Sattar.
I'm along with my associate Haripad Man. I was appearing in the writ petition. I was the petitioner in the writ petition.
Okay. Mr. S.D. Das, learned. So you have this
Along with my associate Haripad Man.
Mr. Haripada Dhanvanti appears for the sole respondent. We request Mr. Bahadur to supply a copy of the memorandum of appeal along with the miscellaneous application to Mr. Das and Council in course of the day.
My lord,
I'll let the matter be listed on Tuesday next.
it was posted to 11th. 11th it was.
Earlier it was pushed to 11th.
How this matter has been listed today?
On mention, my lord, this one is on mention, it has been listed.
Oh, list on the date as fixed by the order dated 28/7/2023 already. Why do you fix matter you mentioned already?
No, I have not mentioned, my lord. 11th September.
11th September.
Means
Item 25.
Lossi, I don't remember appearing from the subject Lossi. In this matter, we have the instruction to appear in this matter. And we file objection to the delay petition. To which time may be granted.
We will file objection.
Objection to the delay.
Already.
Delay of 21 days.
In this IA 101 180 89 of 2029. At the request of your Mr. Devashish
Hajra,
Plan Council appearing for the opposite party, let the matter be listed on even September 27th September 2023. Meanwhile, the opposite party shall invariably file the objection because for that purpose, no further accommodation will be made. Mr. S.S. Paril and its additional standing council, commercial text and GST as a petition.
Item 26.
May Lordship. On behalf of Mr. K.K. Sahu, I want to try for 1 week time.
On behalf of
Mr. K.K. Sahu, Kirat Kishi.
why you are seeking time?
He is suffering from fever.
All right. What is your good name, sir?
Dilip Kumar Samal. Dilip Kumar Samal.
D.K. Sahu.
Dilip Kumar Samal.
Samal. Let me request of Mr. D.K. Samal, Planning Council, appearing on instruction of Mr. K.K. Sahu.
Yeah.
And council who has appeared for the opposite party. Let the matter be listed on 27th of September 2023. Mr. S.S. Pari, Learned Original Standing Council, CT and GST appears for the revision petition.
Item number 27 also.
27 wallet same. 26, 27 same opposite.
Same opposite parties.
Next petition.
Yes.
2014. All right. Same order in 27. Next.
Item 28.
Item number 28. While appearing for my client, Lord, I'll be praying for some time because in this case, Lord, this is a peculiar case. I am defending my client and performing the onerous duty of defending my client who is suffering from a delay of 499 days. And I would like to bring to your Lordship's attention the order passed by the Honorable Supreme Court in so much petition where the delay of almost 2 years has been controlled. That is one factor during the COVID-19 period. And other factors is that, Lord, I would insist before this court that in the impugn order itself, I am not paying for any relief, Lord. I filed a writ petition. I pursued the writ petition for 15 years. Thereafter, due to the fault of the client, it was dismissed for default. It was not restored in time. My restoration petition was also dismissed.
challenging the dismissal of the restoration petition, I am here. What I say, my lord, this is the trade law that due to the negligence of the conducting counsel, the client should not suffer. Number one.
You say that your client did not instruct you, that is why it was dismissed.
Milord, actually, the thing is, from my Milord, I go in unconditional apology, Milord. From the interim order itself, it will speak.
We will not allow to breathe the hot and cold at the same time.
Milord, what I heard,
Firm and candidly submit, it was the fault of the client. Counsel could not appear so that the client should not suffer. That we consider this.
Milord, what I pray, Milord, some time may be allowed so that I will be placing the judgments and I will be.
We do not require judgment. But clear you stand. What stand actually you are like to take?
Milord.
I think usually this who is appearing for the state in this matter?
I am appealing.
I think in this matter usually we take a very lenient course when the lawyers absence the.
No, you let me kindly vigilate two situations.
There are several situations. Only
petition was
multiple situations.
No, writ petition was dismissed for non-appearance of the counsel. That is one matter. Admittedly, the CMAPL was filed at a later stage. That has been rejected. Now, you lordship can see the CMAPL order when it was passed. That was passed on 19/1/2018.
19/1, yes.
Yes. 2018 at page 39. Now the writ appeal has been filed on 23/2022.
What sufficiency of cause because the client did not contact? What is
that is in the first instance. That is in the first instance for non-appearance of the counsel. But so far as second instance,
I understand.
Yes.
Whether the client was informed by the lawyers that your matter has been dismissed.
That is not there.
That should be there unless how can you say that is a deliberate delay? In both the counts, the counsel is responsible. First of all, the dismissal for non-appearance. Secondly, for non-communicating that order to the client. Usually clients are fully dependent on the lawyers. This the physical reality, you cannot just be oblivious when passing on the orders. And moreover, the principle of substantive justice allows the court to take a very liberal view. We allow the appeal, also set aside the order and fix the writ petition for hearing.
Private parties are there. Private parties are there.
So we have to issue notice in this matter, okay. But you have to take a very clear stand in future, I am telling you. That I think interim application first notices to go to there also. Just I number 5550 of 2023. This is an application under section 5 of the Limitation Act for controlling the delay. So there is a delay of 1,499 days in filing the connected intercourt appeal. Issue notice that to why the same delay should not be controlled shall not be passed. Notice is made returnable on 4th August 2023. Steps for service on opposite parties number. On
5 and
party
6.
number 5 and 6 shall be taken by the applicant within 3 working days from today. Very simple. So since Mr. P.K. Mudulil, an additional government advocate, appears and gives notice for opposite parties number 1 to 4, no formal notice is called for. These steps Or two are the opposite parties only. Or
Obliged, much obliged.
Item 30.
Very clear, Lordship. I filed this writ appeal. There has been delay of 29 days. And on the merit, I'll place.
yes,
My lord, I have filed one synopsis. Page 2, my lord will see. There is 2 genealogy. In 2 genealogy, there are 3 summarily.
yes, already there is a delay.
Delay of 29 days.
All right. So we issue in this condemnation petition, no order has been issued as yet. We issue notice. Heard Mr. N.P. Korijal and counsel appearing to the applicant. The same order. IA number 1049 of 2023. In the delay of 31 days.
29.
As per the stamp report. Right. You have calculated 29, this stamp report has calculated 31 days. So you are issuing notice on 31 days.
My lord.
All right. Steps within 3 working days. Returnable days is the 4th October.
By Monday,
3 working days. All right.
Item 31.
Yes.
My lord. The matter was before my lords yesterday. Lordship, on my delay application, lordship has condoned the delay 127 days. 127-day delay. And another why the for dispensing
30 days. Last occasion also I told you 130 days. Anyway. And there is a dispensation application also?
Yes, my lord. I have filed the Xerox copy.
I don't think that you have objection regarding dispensing with the filing of the certified copy.
Certified copy, I should not be.
That is right.
So far, the limitation is concerned.
2298 of 2023. There is an application seeking dispensation of filing of the certified copy of the order dated 23/11/2022, which has been challenged first in WPC number 6076 of 2020, which has been challenged in the connected intercourt appeal. Stop. This 29. It's all. 31. Huh? 31. So, Mr. Shatabrata Mohanty, Plan Council appearing for the opposite party has raised no objection. Stop. Having heard Mr. M.K. Pantel under AG, Additional Government Advocate, we allow the appeal to be filed without the filing of the certified copy of the said order 23/11/2023, subject to condition that the certified copy shall be filed by the appellant. Now we are allowing to appeal, dispensed that filing.
There is a limit.
Within a period of 30 days from. Yes. Accordingly, this application stands allowed and disposed of. Now come to the WA.
There is another IA that limitation. Condemnation of delay 127 days.
that 130 days, that has been condoned. That limitation has been condoned yesterday.
Condoned.
Condoned.
It has not been condoned.
Yesterday, the matter was,
Oh, yes.
and my learned friend has not objected for condoned.
Yes, yesterday that was condoned with your consent only.
Consent, the rehabilitation assistant.
Knowing
the order was passed and
you wanted an early hearing of the writ appeal, that is why you allowed it. Yes. Can the matter be taken up on Tuesday next? Release the matter, appeal. Huh? It's supposed to. Because the order did not release. No, we are mentioning.
Gathered that information that similarly situated matter so far the rehabilitation is concerned.
We know that is the reason I am deferring the matter. Tuesday, stop. At the admission stage, there shall be an attempt to hear the appeal on merit.
Item 32. May it please your lordship. 32. I am filing the objection to the IAO limitation petition.
All right.
May I place my lords? The IA is at flag E. There is a delay of 64 days. And I have explained that paragraph 5 and 6. The judgment was passed on 24th February 23. This was a judgment in a batch of cases considering the validity of the biometric system of attendance in the corporation. One of the writ petitions was challenging 2 disciplinary proceedings. In the present writ appeal, I have only challenged the quashing of the disciplinary proceedings. Because of the large number of issues involved in that writ petition, Your Lordship, it took some time to examine the issue. Thereafter, it was placed for opinion of the learned AG. The opinion was received on 17th April 23, and finally the matter was an advocate was engaged on 18th April, and the writ appeal has been filed on 30th of May 23 during the summer vacation.
Okay. What is the judgment of the learned single judge?
Your Lordship may kindly have the writ appeal. The judgment starts at page 28.
Annexure 1?
Annexure 1, Your Lordship. This was a batch of writ petitions challenging the biometric system of attendance. The learned single judge has upheld the policy regarding the biometric system of attendance, but as regards the respondent, 2 disciplinary proceedings have been quashed. Your Lordship may kindly have the conclusions in the present writ petition, the challenge to the present writ petition at page 84.
What is that?
I'm sorry, Your Lordship.
What is there in 84?
Page 84 of the impugned order, Your Lordship.
All right.
The conclusions arrived at in the impugned order. I am only challenging the findings in this writ petition.
What is that finding?
Your Lordship, WPC number 12689 of 20. That is at page 84, the findings.
Yes.
The disciplinary proceedings have been quashed on 4 grounds. Your Lordship has page 84?
Yes.
I'll read that WPC number 12689 of 20. This writ petition has been filed by the petitioner to quash both disciplinary proceedings number 92 dated 6/7/15 and number 122 dated 23/8/15. Upon hearing learned counsel for the petitioner as well as the learned counsels appearing for the opposite party corporation and the government, and upon a careful consideration of the materials placed before this court has no hesitation in coming to a conclusion that the basic premise on which the charges have been framed against the petitioner are directly relatable to the conduct of the petitioner as the General Secretary of the Employees Union in question. This is finding number 1. It is an undisputed fact that there was a dispute with regard to the introduction and implementation of the biometric attendance system in this office. Such decision was challenged before this court by filing a writ petition at the instance of the Employees Union, though the petitioner as the General Secretary of the Union. Further, in this is finding number 2. Further, in the said writ application, this court had passed an interim order protecting the Employees Union, which had been elaborately narrated in the preceding paragraphs. Finding 3. Moreover, the procedure followed in the dispute proceeding by appointing a retired officer who was appointed as a contractual officer, as inquiry officer, and further the petitioner was not provided with the documents to file an effective reply to the allegations, and further taking into consideration that there was a delay in concluding such proceedings, all these facts raise a doubt with regard to the genuineness and bona fide of such proceedings. Fourthly, moreover, approval of the government has also not been obtained, at least the same was not shown to this court for continuance of such proceedings after retirement of the petitioner with effect from 31st July 2019. I will deal with all 4 grounds, Your Lordship. If Your Lordship may kindly have the Odisha Civil Service Pension Rules. If Your Lordship may have this book. Pension Rules. Hey.
Are you prepared today for?
No, I am just filing the objection, madam. Not the non-married
You
madam.
have started submitting on marriage. About Tuesday next week, try.
Madam.
We also the pass order in the, because the delay is not very inordinate.
Well, let me on that date, madam.
We are not passing any order today. We'll hear you and then pass the order. Your good name, sir?
Ashutosh Das.
Ashutosh Das and counsel has appeared for the the opposite party. Just it is in the IA, huh? But Mr. Heda,
Your Lordship,
from the cost title, we cannot identify which one is for the condonation, which one is for the stay.
But flag E is the condonation of delay. IA number
506
Your Lordship, that is for condonation of delay.
Of 2023. Will be expected by Mr. Ashutosh from counsel has appeared for the opposite parties. You are appearing for all the opposite parties?
There is only respondent number 1 here. Only one respondent.
One. For respondent, 1 madam.
All right, for the appearing with the opposite party. Well, stated that the objection has been filed. Yes, they have put condemnation. That's the matter we listed on in WA number also was in order. List on
Item 33. Well, there's also an IA number 1196 of 3117 of 23 for dispensing with certified copy. I've already obtained the certified copy. I'll file it by the next week.
So file it and mention dispense it.
33.
No, it is for the appellate. When the matter is taken up for consideration. Place the matter on 11th of September 2023.
Yes, Lordship. 34 item.
You are appearing?
33. Yes, the order dated 17th of this month order was passed regarding to hear the matter question of maintainability of LPA.
All right.
First of all, 33.
Your Lordship,
You are appearing in this matter, item 33 LPU 1 of 2023.
Your Lordship.
33 quorum.
33. 33. You are appearing in 33. Why?
Your Lordship.
Next quorum.
Yes, 33.
Yes, yes, then 33. Your Lordship, 33. Please to tell.
You are Mr. Sudhanshu Shekhar.
Yeah.
33.
Your Lordship, 33.
How it is maintainable? Tell us.
Your Lordship, I am relying the decision of Honorable Apex Court. 3 number of decisions.
Sure.
Although, Your Lordship, I would like to satisfy regarding question of legal aspects. The 1/7/2002, the cutoff by the legislature. 1/7/2002, July 1st July 2002. Then before prior to the cutoff date, the 1976 is the amended.
Yes.
1976 amendment 60 also cut off. After 2 amendment, the CPC, amending the CPC, the legislature, the Supreme Court has opined and has settled the question of tenability of LPA after 2002 by deciding the specially petition civil numbers 11,945 with some other SLP petitions there with it. In which the Honorable Apex Court has categorically stated regarding question of tenability of LPA. Just I am relying the decision and just in gist I am just satisfy the court. From paragraph number 1 to 7 of said decision reported in AR 2011 SC Supreme Court RPA 2649. The opened by Justice Akhtar Alam and RM Lodha. Where
Yes, will you repeat the citation?
citation in reported at AR 2011
SC.
SC Supreme Court at page 2649.
Yes.
In which Your Lordship has categorically stated, just I am perusing from paragraph number 1 to from paragraph 1 to 7. Normally, once the appeal reaches the High Court, it has to be determined incorporating to the rules of practice and procedure of the High Court, and in accordance with the provisions of the chapter under which the High Court is constituted and which confers on the power in respect of the method and manner of existing that power. Para 2, when a statute merely directs that then an appeal shall lie to a court already established, then that the appeal must be regulated by the practice and procedure of that court. Para 3, the High Court derives its intra-court appeal jurisdiction under the chapter by which it was established, and its power under the latest patent were recognized and saved by Section 108 of the Government of India Act 1915, Section 223 of the Government of India Act 1935, and finally by Article 225 of the Constitution of India. The High Court therefore cannot be divested of its latest patent jurisdiction unless provided for expressly or by necessary intendment by some special statute. Serial number 4. If the pronouncement of the single judge qualifies as a judgment in the absence of any bar created by the statute, either expressly or necessary implication, it would be subject to appeal under the relevant clause of a latest patent of the High Court. Serial number 5. Since Section 104, subsection 1 of CPC specially saves the latest patent appeal, it could only be excluded by the express mention on Section 104 within bracket subsection 2 of 104 of CPC. The maintainability of the latest patent appeal is saved by virtue of Section 1041.
serial number 6. Limitation of right of appeal in absence of any provision in a statute cannot be readily inferred. The appellate jurisdiction of a superior court cannot be taken as excluded simply because a subordinate court exercises its special jurisdiction. Serial number 7. The exception to the aforementioned rule is where the special act sets out a spell content code, and in that event, the applicability of the general law procedure would be implied excluded. The express provision of need not refer to or use of word. Provision need not refer to use of word letters patent. But if on a reading of the provisions, if it is clear that all further appeal are back, then the letters patent appeal would be back. Para number 29 is enhancedly explained by the Honorable Apex Court. Apart from it, another decision also relied.
That AI 2011, what are the names of the parties?
Furious Lawson Limited versus Jindal Exports Limited. With Jindal Exports Limited versus Furious Day Lawson Limited. IT India Private Limited versus Mukesh Sharma and others. With Shivana Perai.
One moment. The name of the first party.
That is FUERST.
FUEI.
Furious Day Lawson.
Oh.
Versus Jindal Exports Limited.
All right. Thank you.
And another also the reported decision, reported in AR. Yeah, 2002 SC Supreme Court page 189. In which I have not collected the exact decision law journal.
AIR 2002.
2002
Supreme Court.
Supreme Court at page 189.
How party rana?
It not just placid produce.
Judgment.
Collection I have not collected the decision, but a decision that I would like to satisfy.
If you have not read the judgment, how can you read from the?
This section 104 of the CPC. The repeal that has been made in this provision, after that, how a letter patent appeal can survive. That is the sole issue that we have raised on the last occasion also.
Your Lordship, the question arises whether the single bench judgment maintainable before the division bench or not of the same court, of the said High Court.
That issue has been decided.
No, Your Lordship, what happened? There is no hard and fast rule. In letters from the intra-court appeal, if there is specific provision in particular court.
Sorry, this inter-court appeal from the order passed in the writ petition has been made by the High Court by amending and incorporating the appellate provision in the High Court rules.
Your Lordship.
Right, so the appeal cannot be by principle. Appeal must be the product of the statute. Otherwise, there cannot be any appeal.
Article 4, clause 10 and 12, Bihar and Patna. Orissa, clause 10, 12 clause Bihar. Clause 12 of the.
You show from the High Court rules that the High Court rules still permits you to file a letter patent appeal.
Your Lordship.
Otherwise, you have no case.
Your Lordship, section I have first.
From section 104, the provision of letter patent appeal has been repealed, and that also without any substitution.
After 2002, there is no hard and fast rule, and in certain contingency.
This is not a question of hard and fast rule. It is a question of where is the provision for appeal. Appeal must be preceded by a statutory provision. Someone cannot imagine this should be filed before the authority to be treated as the appeal. That is not the law.
Clause 10.
The law is well decided. Your Lordship may kindly say clause 10 of the letters patent appeal. It prohibits writ appeal against an order passed in a criminal matter. That my Lord.
This is another aspect. I understand the inland position.
That is why I am showing you the High Court rules.
Yes, no, this honorable court also in full bench laid down that in criminal matter
in which year?
2017 or like that.
Or could
My
you
lord, Mr. Gautam Misra was appearing before the criminal matter, Your Lordship. And the law laid down by Honorable Supreme Court in AA 2017 Supreme Court 1535, Ramkishan Fauji.
There they said no.
Paragraph 49. That says in criminal matters, no writ of appeal.
No, we are not concerned. Maybe
Yes,
criminal matter.
Lordship question is different. Whether
All right, we'll take up the matter after lunch.
Item number 35, that leprosy colony matters, my lord.
That will be taken up.
Taken up, my lord, at 2.
So it's after lunch, all the matters, we are on 32 now.
two matters fixed at 2 p.m.
All right, let us see. This matter will take up on priority.
So Lordship, item number 34 Lordship. So Lordship, I pray some more time because I have not contacted since 16 years of that respondent Lordship.
Look into the report and then
Please. I will pardon for my mention, my lord. So item 34 Lordship. So I want some time, my lord, because I have not contacted with this respondent since 11 years Lordship. So also I have given the letter Lordship. My letter was required to file an objection to the bill. Yes, that Lordship, in the last week Lordship, the director. Because so I have no also the details, only this judgments and the Sierra petition which my lord friend has sought last week Lordship. I want some more time Lordship.
Because you are talking against the order of the
Yes, so there is a delay when filing the. Yes, boss.
You think the court is attempting back after all these years?
No, when by the last order, Lordship was directed by learning friend to file an objection. If you have this.
27 years.
No, yes, Lordship.
No, not 27.
Yes. It matter of 2003, that is 20 years Lordship.
Almost.
So if you not file an objection, like
Don't file the objection in dispose of the matter.
because Lordship, I have not contacted since 11 years to the accused.
If
This is the problem.
What is the problem?
So problem because I have only this.
Problem is if.
So I have not prepared Lordship, so I'll file the objection to that limited Lordship.
It's not the case, perhaps,
Yes, Lordship.
You cannot just come to the court and say 11 years and compare years.
So that also.
The first time in the mistake today, it was also listed on.
Last week also.
2023, you know this matter is taken up today.
Now that takes because I have not appeared on the misconception that this file has gone to Mr. Dipti Hall, that is the senior counsel. Thereafter, the last week I had appeared Lordship.
This, I also from that side.
Yes, Lordship. Yes, Lordship.
It's one of the tactic followed by the council, but in the 2006.
Yes, Lordship.
Similarly, application is not generally granted. You were there, we'll see.
Lordship. Lordship.
All the amendments.
One week.
So, Jenna, you file a, you will take up the matter tomorrow. If I am reaching some action.
Well, and you'll have to,
And your list of citations.
no, other citations.
So, you file the citations and you point to submission and then file the order. File it tomorrow.
You'll have to day after tomorrow, maybe. Tomorrow,
Okay.
I will be absent.
Okay.
You'll not see memo, it may be received.
So those are I will comply. I will comply. But memo, the decisions I would like to satisfy. Hello. Okay.
Bathroom matter, I don't know, 18. Any information?
Yes, my lord. The girl, Oblige, my lord. I will not wait for the order to be. I'll immediately do that. I'll immediately do that. Oblige, my lord.
Matter fixed for 2 p.m. Item number 40.
I think the matter is closed, but you only allow them to file an affidavit explaining that within 3 years or beyond 3 years. That matter, that validation of that select list within 3 years and after 3 years. And we said that 107 persons have been promoted subsequent after 3 years. They wanted to verify. They have filed an affidavit.
Yesterday, I saw the copy on my lord senior. And that position I have clarified, my lord may kindly see paragraph 3.
Excuse me.
Yes. So that is the lead case. Paragraph 3, internal phase 2. May I please? That as per clause 5 of letter number 3962 dated 13/8/2007, the list prepared on 16/10/2007 was to remain valid till 15/10/2010. During the validity period of the result of the promotional pre-promotional test, 3 numbers of CSBs were held and 157 numbers of candidates were allowed to go for assistant station officer course of training. In order number 118 dated 21/10/2010, under annexure 6 to the repetition, 107 candidates were allowed to undergo the assistant station officer course of training on the basis of the CSB held on 12/10/2010. Needless to mention that it is the date of CSB which is relevant for the purpose of training. 107 candidates were allowed to undergo the assistant station officer course of training on the basis of CSB held on 12/10/2010, which is within the validity period of the result of the pre-promotional test board. Therefore, there is no error in sending the names of the 107 candidates by letter number 118 dated 21/10/2010, which is only a clerical act. So that is the main element, and other parts. Then in paragraph 4, we have stated about 18 persons who were allowed after the validity period of the select list of 3 years. And we have also stated that there can be no negative equality. In paragraph 4, we have stated. Now they are claiming that in view of annexure 6 and 7, so we should be given similar promotion like.
You have to admit that annexure 6 and 7 are improperly or irregularly done. Otherwise, the concept doctrine of the negative equality will not come. You have to admit that that was not done according to the law.
Yes. That we have stated in paragraph 4.
Oh, yes.
That so far as order number 124 dated 10/11/2010 under annexure 7, selecting 18 persons to undergo assistant station officer course of training is concerned, CSB was conducted on 8/11/2010, that is beyond the period of the result of the pre-promotional test board on 16/10/2007. Said 18 candidates were sent for training, keeping in view the urgency of the matter to fill up the vacancy. It is well settled that no party can claim negative equality. Furthermore, their promotion is not under challenge.
You don't say that is illegally done.
So we have stated that they were allowed beyond the period of 3 years.
Beyond the period of 3 years, maybe your distinction, you are extending the life of this panel also. It is not a statute that is authoritating this thing.
And file specific affidavit that yes.
Very well drafted petition. Without admitting your own lawyers.
No, I'll file only short affidavit only to that expect to relating to Annexure 7.
We are reserving the judgment.
Yes.
By the laws. It will be one page affidavit.
Yes. And last occasion, my lord,
I can add about this affidavit. Your lordship wanted to know whether promotion has been given beyond 3 years or not to that 107% and 18 persons. So for 107%, they say that giving promotion subsequent to 3 years, but the Departmental Promotion Committee recommended their case before prior to expiry of the validity period. That is what they have said.
That was
The Departmental Promotion Committee, CSB, they say that Central Selection Committee has, yes, they also look to the date. The para 3. They also look to para. Yes, sir. Same person. 107 and 18.
all are activities.
Yes, sir. Well, one question put to myself, but the contention they have raised before the division bench, so far the state is concerned that the validity of the list could not expire till it is exhausted, and accordingly we are giving appointment and promotion. Now can they, because that very order is sought to be challenged before the lordships, because they are not parties. Now can they stand down and say that that is because they've changed their pleadings?
They were supporting their case.
It's the entire case of the petitioners. Throughout, there is no dispute over this.
Our plea has been negated by the Honorable Division Bench. Therefore, matter carried to the Honorable.
Therefore, you change your
the SLP has been dismissed. So we cannot now turn around at the same stand. Now we are bound by those two orders.
That you can say, but you can't say that whatever pleading you have taken, now you can change it.
Now that order is binding on us. Both the orders are binding on us because we are the parties in both the proceedings.
Accept that part of the fact, whether it is beyond or within. There is all the matters that came to the law.
Right, sir.
The other consequences follow.
Right, sir. Right. Minus.
That your plea is that until the list is exhausted.
Yes. Yes.
They said the limit is 3 years. All this, the appointments or promotion.
And that 3 year is not supported by the law. This, that is not approval of the state government. Point of law, we have clarified that.
And if that question of the order, that 4 words, within the validity of 3 years, if that will be there, that will also applicable to the 107% and this 18%. Is it their case that they will be voted back?
No, they are not saying there's a.
That's it. That is exactly the point.
They are saying we just attack. We are not concerned about this purpose. We are not challenging the requirement. They have also no responsibility also to make.
Yes, sir. Yes.
There's a result done regularly, but you cannot get any nourishment from them.
That is in that case.
One more thing, your lordship say, approval of the annexure 1 is not there also.
Well, before my lord, senior, my last occasion also, my lord directed to give me a note, bullet wise. That yes, sir.
My lord, approval of 1 is not made by the state government. When that. Then for one person, you say that state government is not, when it is 3 years, that is for state government approval is necessary.
So far as we are concerned, we will also give a note by tomorrow, day after tomorrow. That's the closing. Short note, 2 pages. 2 pages.
And if you accept the judgment in which I argue the matter, that is after 20 vacancy, there is no vacancy at all. There is no vacancy at all. There is sort of decision. It might be recruitment, the policy may be followed here. And it is specifically stated that until by end of end of the year 2007, this will apply. And they have affidavit stated that this total.
The only cases that present appellants, they should not be.
Yes, my lord.
On the trial list.
If your lordship recall the judgment, then another person, another group will come. There is nothing bar because it is there.
His clients have challenged this order before the Supreme Court.
And his case is entirely that the percentage. His case is not this validity. Rather, he accepted the validity period. Now, now,
That challenge, but that also you want is extra dismissed. But it was not admitted. Although SAVITRI is not admitted. For their case, when it is a case of recording, dismissal is not clubbed together. Now, when my case, how to be clubbed together?
Basic case.
Why not?
How can you shape your case was that on that day also you argue that the 50% cannot be accepted, only the 30% limited to the
This is that, your lordship's judgment, the police department, I know that is 30%, instead of 30%, they have filed 50%. So that is challenged in the Honorable High Court. Honorable High Court said that this is not taken the consent and it is partition of 30%. With that, there is another circular was issued, that is annexure 6 of the 13566. 13566. That circular says that it is 30%. On the basis of that judgment. Well, lordship say it might be.
On the basis of the 30%, you are saying there is no vacancy.
Yes.
No vacancy.
See, 30%. 50%.
But your case should be that on the basis of the 30%.
30%, 50% is a challenge that I mean, I'm 7 also. I'm 1 also. In that case, when the judgment is delivered, it says that once you have accepted the annexure one, then you cannot go back. So you cannot turn back. Now, the same thing applied to the also. They have also appeared in that exam. That is 3 years there. So when it is 50% and 30%, then this circular is good. When circular is not good. When it is 3 years, that is also in that 3 years. The circular is not good. How they do? Hot and cold are in the same time manner.
Would you like to file any written note?
I have already filed a submission. Yes, I will file.
Beyond that, you will not file.
Yes, I have filed a submission.
No, you have filed one.
Yes, yes. Well, I short note explaining.
Fix the matter tomorrow only for filing the written.
Yes, that's right.
Yes. Yes.
Right.
I have also, I will also file a short additional note. Additional note I will file.
One way, so many notes. This one you can take and give.
Even affidavit and something.
You want to file an additional note?
Yes, I have prepared. You will grant me liberty, I can pass.
If that wouldn't know, you can file a comprehensive note.
That is covered, man. Give a copy.
Border, na? Additional note. So this covers that 1 page note also?
Yes.
Okay, then we are not.
Then all right. Then also close it so that so far we are concerned, we will give a 1 page note tomorrow. And I will supply those citations in course of the day.
You are not going to file anything.
Yes, affidavit tomorrow I will file. So far we are concerned in that.
If it is concerned, you can fix it better tomorrow.
Yes. Sir, कौन से करने हैं? affidavit जो देखते हैं,
Explaining the
Yes.
My lord, in WPC number 33992, last case, I have filed a short note, my lord. Oh, bless.
Item number 50.
Item 50.
You must be referring to 31/7 minutes? Yes. 31/7. But wait, please, Your Worship. But here precisely, the matter has been argued before Your Worship. Primarily on the questions that the procedure has not been followed, and therefore the order is a nullity. Secondly, the order of the council is not a merit. Thirdly, no hearing, no opportunity of hearing has been given. And fourthly, there's a question of limitations so far the claims are concerned. And lastly, they refer to two decisions of the Supreme Court. Well, that they are the primary grounds on which actually the argument was advanced. But with due respect, I would like to take your steps to the provision of law that is there so far as the Act is concerned. We're trying to look at section 2 small e.
On 31st of July, when the last hearing took place, those provisions were exhaustively responsible for the other members.
But the appellate court order has not been placed before. Let's say I'll place today, my lord. I'll justify that the honorable single judge, my lord, was delivered the judgment, has dealt with each and every aspect of the matter. That I'll show you for lordship. But before that, can you, lordship, my lord, look at the provision of law first, my lord? Yes. That was placed before lordship last time. But actually, I would like to place it the way actually I want to show how the law supports so far as my case is concerned. But kind of section 2.
State your refer in which part and what way you like to present this provision, but for nothing related to what was your interpretation, or it differs from the interpretation of the appellants.
Sir, your answer is absolutely correct. But I would like to show that before lordship, that how I come in the category of small scale industry or entrepreneur for the purpose of advancing my claim under the statute itself.
Okay.
If you kindly see 2E first, Marad. Enterprise. Section 2E. So enterprise means an industrial undertaking. Let me kindly mark, that's the first thing I would like to bring your notice. Petitioner is an industrial undertaking. Or business concern
any other establishment by whatever name called engaged in manufacture or production of goods. I am a manufacturer and production of goods in any manner pertaining to any industry specified in first schedule to the Industrial Development and Regulation Act, or engaged in providing or rendering any service or services. I also come within the definition of within the first schedule of that Industries Development and Regulation Act itself. But if you also kindly turn to small m of 2, section 2, it says small enterprise means any enterprise classified as such under subsection italic 2 of clause small a of subsection 2, italic 2 of clause b of subsection 1 of section 7. So we have to go to section 7, Malad. Section 7(1) says, notwithstanding anything contained in section 11B of the Industries Development Regulation Act 1951, the central government may, for the purpose of this act, by notification and having regard to the provision of subsection 4 and 5, classify any class or classes of enterprises, whether proprietorship, Hindu undivided family, association of person, cooperative society, partnership firm, company, or any undertaking by whatever name called. Company is also included, but you kindly mark. So here the classes of enterprise, whether proprietorship so and so, company also comes within the purview of enterprise. Is inclusive. But now you also can see small a, in case of enterprises engaged in the manufacture or production of goods pertaining to any industry specified in the first schedule to the Industries Development and Regulation Act 1951, small micro enterprise, 2 comes small enterprise. So I come within the purview of section, this clause 2. Whether the investment in the plant and machinery is more than 25 lakhs rupees, but does not exceed 5 crores. We kindly look at the explanation 1. For the removal of doubts, it is hereby clarified that in calculating the investment in plant and machinery, the cost of pollution control, research and development, industrial safety devices, and such other items as may be specified by notification shall be excluded. So that is how they compute the investment in the plant and machinery, which if it comes within the 5 crores zone, then it can be declared to be a small scale industry. And registration has to be done accordingly. So now kindly turn to section 15, Marad. This is delayed payment to micro and small enterprises. So I come under this chapter, chapter 5. 15 says, wherein a supplier supplies any goods or renders any service to any buyer, the buyer shall make payment thereof on or before the date agreed upon between him and the supplier in writing, or where there is no agreement in this behalf before appointed date, provided that in no case the period agreed upon between the supplier and the buyer in writing shall exceed 45 days from the day of acceptance of the day or day of deemed acceptance. So this is a period of 45 days is specified here. If they do not pay, then they come within the purview of this liability of buyer to make payment. I am the supplier, they are the buyer. Now, sir, kindly see 16. Date from which the rate at which interest is payable. How the interest is calculated, that is specified here. Where any buyer fails to make payment of the amount to the supplier as required in section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier, or in any law for the time in force, be liable to pay compound interest. That's very kindly mark, compound interest with monthly rates to the supplier on that amount from time the appointed date, or as the case may be, from the date immediately following the date agreed upon at 3 times of the bank rate notified by the Reserve Bank. Section 17 speaks about the recovery. For any goods supplied or services rendered by the supplier, the buyer shall be liable to pay the amount with interest thereon as provided in section 16. Then comes the provision which requires adjudication. First comes section 18, clause 1. It says, notwithstanding anything contained in any other law for the time in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to the Micro and Small Enterprise Facilitation Council. Clause 2 says, on receipt of the reference under subsection 1, the council shall either itself conduct conciliation in the matter of or seek the assistance of institution. The council shall either itself conduct conciliation in the matter or seek the assistance of an institution or center providing alternative dispute resolution services by making a reference to such an institution or center for conducting conciliation, and the provision of section 65 to 81 of the Arbitration and Conciliation Act 96 shall apply to such disputes as if the conciliation was initiated under Part 3 of the Act. Quite clear. Thereafter, if you also kindly turn to clause 3. Subsection 3, subsection 3, where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself, again, sir, the council can also function as an arbitrator, either itself take up the dispute for arbitration or refer it to the institution or center providing alternative dispute resolution services for such arbitration, and the provision of Arbitration and Conciliation Act shall then apply to the disputes as if the arbitration was in pursuance. Well, that word as if is very important. Well, it will just adopt itself to the arbitrator, the procedures will follow. Was in pursuance of an arbitration agreement referred to in subsection 1 of section 7 of the Act. 4 says, notwithstanding anything contained in any other law for the time in force, the Micro and Small Enterprise Facilitation Council or the center providing alternative dispute resolution services shall have jurisdiction to act as an arbitrator or conciliator under this section in a dispute between the supplier located within its jurisdiction and a buyer located anywhere in India. That gives the jurisdictional partner. 5 says, subsection 5, every reference made in the section shall be decided within a period of 90 days from the date of making such reference. Supreme Court has clarified this 90 days to be in close proximity, maybe exceed a little bit, but it has to be as quickly as possible in the summary manner. Then clause section 19, let's kindly see.
Yes.
It's an application for setting aside decree, award, or order. The statute provides that if an award has been passed or a decree has been passed and an order has been passed, there said no application for setting aside any decree, award, or order made either by the council itself or by an institution or center providing alternative dispute resolution services to which a reference is made by the council shall be entertained by any court, unless the appellant, not being a supplier, has deposited with it 75% of the amount in terms of the decree, or as the case may be, the other order in the manner directed by such court. Provided that, pending disposal of the application to set aside the decree or award or order, the court shall order that such percentage of the amount deposited shall be paid to the supplier as it considers reasonable under the circumstances of the case, subject to such condition as it deems necessary to impose. This is more like Order 41 Rule 1(3) read with Order 41 Rule 5 of the CPC. Now, establishment is section 20. 21 says about the composition of the facilitation council. Then let's see, the 22 says requirement of specific unpaid amount with interest in annual statement of account. 23, interest not to be allowed as deduction from the income. Then 24 is important, is an overriding effect. Section 24 says the provision of section 15 to 23 shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. Well, that is how the inbuilt provisions are there in the statute for the purpose of challenging the order or decree that when passed by the Facilitation Council. And Section 19 provides for that with a rider that anybody who wants to challenge has to deposit at least 75% of the decretal due.
Why are you making this provision right when it is an intercourt appeal? And Article 226 also you say that this will be applied.
So this also applies to Article 226. There is a recent decision to that effect. I'll cite it for your worship.
Sir, I'm asking this provision for this purpose.
Yes, madam. So the recent decision says of Kerala High Court, I think. Telangana High Court, I'm sorry, Telangana High Court. It says that even in a writ jurisdiction, since there is a mandatory provision for depositing the amount, no court shall entertain, that includes the High Court also. It has to be, they have to deposit the amount. That has not been done.
What is the decision of the
Say, Telangana district. I'm giving this number.
When you say Order 41 with regard to nothing.
Yes, yes, ma'am. Perhaps 36 to 42. Can I just read it, Malad?
No, this one is slow.
Yes, yes, Malad.
It was on para 17, sir. The pre-deposit part.
Para 41, Malad. Para 41. This is more so when there is no compliance to the mandates of Section 19 of the MSME Act, in as much as 75% of the awarded amount was not deposited by respondent 2 to 3 before the registry of this court at the time of filing of the writ petition. It is true that Article 226 of the Constitution of India, being a constitutional provision, would not be subject to the rigors of Section 19 of the Act. Nonetheless, having regard to the specific objective of MSME Act and the fact that the respondents 2 and 3 had not availed the statutory remedy, the award is in the nature of money decree. Entertaining the writ petition without insisting on the deposit of the award, amount was not at all justified.
So, Mr. Bishop, I think what I was actually reading here, it speaks about the duty of the court.
Right.
Right. Under the court, this order, rule 5 also same thing.
Same thing.
In the threshold, it has to determine.
Correct.
What amount has to be deposited by the person who is approaching the court.
Right.
But once also distinction and exception has been made under rule 5 also. But the court can also simply ask for an undertaking or.
Yes. Absolutely correct.
Here says that it was the duty of the court to insist.
So here the question is, so mandatory provisions order 41 rule 1(3) correctly. Section.
No, I'm posing this question differently.
Right.
The court has not asked them to depose it.
Correct.
Now then that shall be the defect. And the threshold and so they should not entertain it.
So here,
perhaps you have also not raised that question at the threshold.
No, we did not. We challenge the maintainability as such. We challenged the very maintainability of the rate petition.
On different grounds.
No, we have said that alternative remedy is available.
Different ground.
Right.
Completely a new ground you are raising the intercourt appeal.
So
actually did not call for consideration of the civil class. So far our discipline is concerned, this we usually do not allow, unless it is a serious question of law, to raise such question in the intercourt appeal.
No, with due respect, can I just explain one thing?
Yes.
Now, I said the statute provides this.
I understand, but I asked you whether that will be first. I asked you, my question was in two parts, whether you also try to impose the proposition in the.
I have not raised that point, but we have argued it before the Honorable Court.
It is more moralistic than a legal restriction.
You also wanted to know that it is permissible or not. That's why I wanted to show you.
It's the way actually no discussion much about this thing because two different structures and both the structures are for a different purpose.
Yes. Absolutely correct, Madam.
So far the precinct of the judicial review is concerned, it's to a very limited extent.
But absolutely correct, Madam. Read jurisdiction. If there are 3-4 judgments to that effect, also I'll cite for your lordship. Regarding the thin aspect is to be gone into for judicial review. So far as Article 226 or 227 is concerned, Madam. I'll cite 3 decisions to that effect. But this is first one. No, yes, is aware of those decisions, Madam. No, I'm just giving just for reference. Punjab State Power Corporation Limited speaks about patent lack of inherent jurisdiction. Patent lack of inherent jurisdiction, then the court can interfere, Madam. But if you also kindly turn to paragraph 2 of that judgment, Madam, first judgment. The K.V. Vishwanathan, the senior counsel appearing for the petitioner, has argued before us based on a judgment, Deeps Industries, often quoted, paragraph 17. This being a case, there is no doubt whatsoever that in the petition we have to be filed in Article 226 or 227 of the Constitution against order passed in appeal and Section 37. The entire arbitral process would be derailed, would not come to fruition of many years. At the same time, we cannot forget that Article 227 of the constitutional provision, which remains untouched by non-obstant clause of Section 5 of the Act. In these circumstances, what is important to note is that though petitions are to be filed on Article 227, it is a judgment allowing or dismissing first appeal under Section 37 of the Act, yet the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy as adopted by us herein above, so that interference is restricted to order that are passed which are patently lacking in inherent jurisdiction. But if you see, kindly turn to paragraph 4, Madam. We are of the view that 4 of read quote from section 16 application being dismissed by the arbitrator can only be if the order passed is so perverse that the only possible conclusion is that there is a patent lack of inherent jurisdiction. The patent lack of inherent jurisdiction requires no argument whatsoever. It must be perversity of the order that must stare one on the face. Then next paragraph, if you actually kindly turn to paragraph 5, unfortunately, parties are using the expression, which is in our judgment, deep industries, to go to the to Article 220 of the court is matter in which do not suffer from any patent lack of inherent jurisdiction. This is one of them. Instead of dismissing the writ petition on the ground instead stated, the High Court would have done well to have referred to a judgment in deep industries and dismissed the Article 220 petition on the ground. There is no such perversity in the order which leads to a patent lack of inherent jurisdiction. The High Court ought to have discouraged similar litigation by imposing heavy costs. The High Court did not choose to do so, either of these two things. And accordingly, Mr. Biswanath argued this matter. It is clear that there is not a case which falls under the extreme exceptional category. And accordingly, dismissed merely. The next is similar. It's a one paragraph judgment. I just got to notice that there also deep industry was followed, and the court also expressed displeasure about such cases being filed. The next case is Vaughan Construction. It is 2022 volume 1 SCC, page 75. There also can you see paragraph 13. Is the Arbitration Act itself gives various procedure and forum to challenge the appointment of an arbitrator. The framework clearly portrays an intention to address most of the issues within the ambit of the Act itself, without there being scope for any extra statutory mechanism to provide just and fair solution. In para 17, therefore, Respondent 1 choose to impugn the order passed by the arbitrator in section 16(2) of the Act through a petition under Article 226 of the Indian Constitution. In the usual course, the Arbitration Act provides for a mechanism of challenge under Section 34. The opening phrase of Section 34 reads as follows: that recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. Thus, use of the term only as occurrence in the provision serves two purposes of making the enactment a complete code and lay down the procedure. So why I read this paragraph, let's kindly see, as per section 18, once the arbitrator on the facilitating council passes an order, that becomes an award. Once that becomes an award, that can only be challenged in section 34, which provides the mechanism for that matter. Then kindly turn to paragraph 17, that refers to Nivedita Sharma's case. In any case, the hierarchy of our legal framework mandates that a legislative enactment cannot be curtailed a constitutional right. Nivedita Sharma's case says, we have considered the respective argument submission. There cannot be any dispute that power of the High Court to issue direction, order, or writ, including writ in the nature of habeas corpus, certiorari, mandamus, quo warranto, and prohibition on Article 220 of the Constitution is a basic feature of the Constitution, cannot be curtailed by the Parliament legislation. L. Chandrakumar's case, however, it is one of things to say that to exercise the power vested in Article 226 of the Constitution, the High Court can entertain writ petition against an order passed or action taken by the state or its agency or instrumentalities, or any public authority or order passed by a judicial quasi-judicial body authority. And it is an altogether different thing to say that each and every petition filed on Article 226 of the Constitution must be entertained by the High Court as a matter of course, ignoring the fact that aggrieved part person has an effective alternative remedy. Rather, it is settled law that when a statutory forum is created by law for redressal of grievances, writ petitions should not be entertained, ignoring the statutory dispensation. Paragraph 19 refers to this one. I am not reading it, Madam. Paragraph 20, Madam. In the instant case, respondent number 1 has not been able to show exceptional circumstances or bad faith on the part of the appellant to invoke remedy under Article 227 of the Constitution. No doubt, the ambit of 227 is broad and pervasive. However, the High Court should not have used its inherent power to interject the arbitral process at this stage. It is brought to our notice that subsequent to the impugned order of the sole arbitrator, a final award was rendered by him on merits, which is challenged by Respondent 1 in separate Section 34 application, which is pending. The viewed from the different perspective, the arbitral proceeding is strictly conditioned upon the time limit and motivated by the principle of unbreakability. Here also 45 time has been granted, Madam. Section 34(3) reflects principle of unbreakability, and that has also been to here. Kindly turn to paragraph 22, Madam. The High Court did not appreciate the limitation on Article 226 of the Constitution and reasoned that the appellant had undertaken appointment of an arbitrator unilaterally, thereby rendered Respondent 1 remediless. However, a plain reading of the arbitration agreement points to the fact that the appellant herein had actually acted in accordance with the procedure laid down without any malafide. So then para 26. Yes. It must be noted that Section 16 of the Arbitration Act necessarily mandates that issuance of jurisdiction must be dealt with by the tribunal, first by the tribunal, before the court examines the same under Section 34. Respondent 1 is therefore not left remediless, as statutory provision provided to change of a chance of appeal. Para 22 of Bipchand's case, they referred to one of the features of the case is some of the importance, as stated above. On 9/5/2018, a Section 16 application has been dismissed by the learned arbitrator in which substantially the same contention in favor of the High Court was taken up. The drill of Section 16 of the Act is that whereas Section 16 application is dismissed, no appeal is provided, and the challenge of the section application being dismissed must await the passing of the final hour, at which stage it must be raised on Section 34. In view of the above reasons, we are of the considered opinion that High Court erred in utilizing its discretionary power available in Article 226 and 227 of the Constitution, that the appeal is allowed and the impugned orders are set aside. The last decision is an order for Justice Honorable Chief Justice Dr. S. Murli. It also refers to that alternative remedy, and primarily a question of alternative remedy has not been availed, which has been confirmed by the Supreme Court in the last judgment I have shown. But I have 2-3 judgments to justify how actually the procedure has been followed. That I will show after showing the impugned order itself. Can I take your issue to the impugned order? Yes. The page 45, and MSME Act provides the specific provisions with regard to challenge the award itself, because they have not availed. So primarily, actually, that's the reason for not to deposit that amount also. But page 45, the order starts, order number 24, dated 4/3/2022. Mr. Das, the Senate advocate, appears on behalf of the petition, draws attention to 2 documents. Page 45, Madam. Yes, Madam. It's ends in 47, Madam. This is one of the issues that has been decided here, Madam. It's a continuation, Madam. It says, Mr. Mishra, senior advocate appearing on behalf of the opposite party number 2 and submits his client has answered by additional affidavit to show that the unit at Khurda has received certification from the authority to be a small enterprise. But just pausing here a moment. Kindly sir, turn to page 66. Page 66 is a document that is Annexure 3.
Yes.
So if you, Lordship, kindly see, it's a little bit not so clear word. I'm extremely sorry. But left-hand side top, the plot number is F9, F16, IID center. It relates to the certificate granted by District Industry Center, Bhubaneswar. And kindly see the date number 6/5/2008. This registration has been granted as a small scale industry. This certificate has been granted by the authority under the statute after verification of records and everything. But it was originally 1977 registered, then 97 registered, and then subsequently registered in 2008. Now all transactions relate to 2009 to 2013 when this registration was valid. Then sir, kindly see the next paragraph in the improvement order. So this certificate was also filed for the authority, filed for the conciliator also, the council itself. Mr. Das, senior advocate appearing on behalf of petitioner, draws attention to two documents disclosed under Memorandum 11 January 2022, filed by the opposite part number 2. The first is circular dated 29 September 2019, issued by the Additional Development Commission, Micro and Small Enterprise. Text of the circular is reproduced below. The matter regarding clubbing of various enterprises, whether located in the same district or various districts of the state, country, under the same ownership, have been examined by this office. The competent authority, after examining the issue in depth, has decided that the investment in plant and machinery equipments of all enterprises under the same ownership, well, kindly mark the words, my lord. The all enterprises under the same ownership shall be clubbed together while assessing the status of MSME as per provision of the MSME Act 2006. Quite clear, knowledge. But enterprises are different units or industrial units which do manufacturing and supply. But a particular owner may be having different enterprises. Each one is an enterprise of its own. So they first decided to club it together for the purpose of calculation. So far the MSME Act is concerned. Now kindly see the next paragraph. The second document is circular dated 3rd March 2016. The text of the circular is produced below. Reference is invited to circular number so-and-so dated 29/9/2015. The top circular number 29/9. Issued from this office. It is to inform that above referred to circular has been withdrawn with immediate effect. This issue, with the approval of the Honorable Minister, Microsoft. But my responsibility is that this inclusive of this 2009 was issued, this is 2015 letter was issued to club each one of the enterprises, was subsequently withdrawn in 2016. But our transaction relates to prior to that, 9 to 13. So this is no way connected. We are not affected either by the clubbing or subsequent withdrawal of the notification. But then para 3, but these are all referred to in pages. If you also kindly see, this document is available as page 328, 329, and 330 of the paperwork. And the withdrawal is at 342. But paragraph 3, he then draws our attention to his client's affidavit in response to the circular. He submits with reference to paragraph 5 of the affidavit on information obtained. There is no clubbing as a result of withdrawal of circular 3rd March 2016. On query from the court, he relies on section 22 and 27 that Mr. Das is referring to. The Micro Small Enterprise Development Act to submit not only is opposite part number 2 ineligible to be a small enterprise, since it's all units clubbed together, will take the working capital above the prescribed limit. The said opposite party did not disclose its claim status and thereby expose his client to penalty in section 27. Paragraph 4 is the conclusive. It says, what emerges is that there is no notification regarding clubbing of enterprise or unit that make the aggregate working capital ineligible for certification as a micro and small medium enterprise, as the case may be. Internal correspondences between departments, office will not be relied upon by the court. There has been demonstration that Khordha unit of opposite part number 2, for that I have shown your lordship page 66, that is Khordha unit, Miller, had received certification. On query from the court, Mr. Mishra clarifies that there was disclosure of the 2 circulars that demonstrate that there was no notification for clubbing and the dispute regarding non-payment arose in the year 2013 to 14. At a time before the circulars came into existence. So this point was argued there and decided. Well, this clubbing part has got a very important aspect to explain your lordship, that one of the points that has been argued that enterprises includes a company. Since Gupta Power is a company, therefore it has to be clubbed. All taken together. I think Gupta Power is a company. Once is a so everything has to be taken up together for the purpose of decline period enterprise. So as if Gupta Power is an enterprise, it contains all those units and has to be taken up together for the purpose of calculating whether it is a MSME unit or not. That is exactly I have understood. That is. But we do respect her.
I did not produce these 2 circulars. I did not rely upon these 2 circulars.
I did not say that.
I'm not saying you said it. All I'm saying is these 2 circulars were produced by him as a learned judge notes, and he explained that the first circular has been withdrawn by the second circular. And the learned judge therefore said there's no clubbing. I am not relying, I did not rely upon before the single judge, and I made it clear to my lords that I am not relying upon either the first circular or the withdrawal circular before your lordship. In my cases, enterprise can be classified. That's all.
May I just request my senior friend that when I'm arguing, actually, you should not.
No, I requested your permission to clarify.
No, I request you, sir. Sir, here actually, enterprise I have read. I have indicated that enterprise also, and also every unit can be called an enterprise. So why I say this, why this clubbing part also I find to justify that each unit or each industrial undertaking can be clubbed together for the purpose of calculating the MSME, whether it comes from the MSME definition or not, for the purpose of guaranteeing a certificate. They have decided to club it for the purpose of that. Itself shows that each one is an enterprise by itself. Quite clever. The very purpose the central government decided and subsequently withdrawn. The very purpose is that they are also conscious of the fact that each industrial undertaking is an enterprise. Right. Circular number 2. Circular number 1 is must. So we have to file it because with due respect, my senior friend was not there. Mr. Das advanced an argument in the court, filed an affidavit. All clubbed together comes from that. That is the reason why we have to file it, to explain. Now they are taking a stand, we don't ask about clubbing. So we don't care, I don't want to converse on those points that whether he wants to raise it here or not. Right. Yes, speculation. No, he has argued it, sir. Mr. Das has argued it before the. Para 2 also they have referred to those documents.
Mr. Das has argued.
But that is what I said. They are not arguing here, that's a different thing. But this point was raised. The purpose of this showing this to your lordship is that every industrial undertaking comes under the definition of enterprise. Company comes under the definition of enterprise. I don't say that company doesn't come. It's inclusive. But every industrial undertaking is also can be called an enterprise. Because that notification, if your lordship looks at 29(9) and 15 notification, the very opening word is the matter regarding problem of various enterprises. Has your lordship got it, my lord? Page 46, top, my lord.
Page 46
top, my lord.
Page 46 of the read. Oh, read up,
my lord. I am referring to the read up, my lord. The matter regarding clogging of various enterprises within bucket, whether located in the same district, got it, or in various districts of the state or country under the same ownership. The owner may be Gupta Power. Gupta Power has in Chennai, Gupta Power has in Uttarakhand, and Gupta Power has got in Khordha. Same ownership. So they thought to club all the units, all industrial, all enterprises. Now subsequently they have withdrawn. But purpose of showing this, that each one is an enterprise. And every district has got a district director of industries. They used to certify whether this enterprise is to be granted the certificate of registration or not. So that inquiry has also been conducted subsequently because they used to do periodical checking. Now, somebody must have acquired assets and all that, and therefore they have to check. For that purpose, I would like to take your lordships to one of the document. Just a minute. Page 45 or so can see. Sir, page 234, let's me kindly see. Page 234. In that readable paper word. Got page 234, my lord. It says status report of Gupta Power Infrastructure under MSME Act 2006 for assessment of plant and machinery. As per decision of the government in MSME department, a committee as follows has been constituted to assess the status of Mrs. Gupta Power Infrastructure Limited F9 F16 IID Center Khordha. I got it, Lord. Under the MSME Act, the persons actually who constitute the committee are the Additional Director Industries, Deputy Director in charge MSME, General Manager DIC, Assistant Director Industries, Assistant Director MSME, and Industrial Supervisor. The committee examined the documents in respect of plant machinery submitted by the unit for amendment of EM2 and under the visit of enterprise on 28/3/2015 for physical verification. The previous status is there, they have quoted history. They have mentioned location is F9, F16 IID Center Khordha. Item manufacture is this. Then EM2 number is given, that is 12/1/77 was issued as per MSME Act 2006. White so-and-so issued on 6/5/2008. That is page 66, my lord. Then date of last inspection 12/4/2012. for amendment of value and plant and machinery. We have incorporated some new plant and machinery and obliterated the old ones and discarded the same, for which we applied that this should be verified. The finding of the committee is that the inspection was conducted in the shade-wise list of Annexure 1. The unit, after installation of additional plant and machinery, had applied for amendment, EM2 of DIC. The list of plant and machinery and auxiliary equipment furnished by the enterprise were checked and with concerned bills, invoices furnished vis-a-vis physical checking. The list at Annexure 1 was examined as per MSME Act. As per the Act, the plant and machinery which are ordinarily considered essential for production have been computed as plant and machinery, and the item like testing equipment, material handling equipment, etc. are excluded. The Senate credit of the central value tax merit, credit of excise duty in education says it has been excluded for computation of cost, plant or machinery as per generally accepted accounting principle. The plant and machinery which are old and obsolete and were not found during inspection, which have been removed from the books of accounts of the company, are also excluded. The equipment, item and obsolete plant machinery are excluded as per Annexure 2. The plant and machinery found during inspection and working at Annexure 3, which amounts to 4 crores 48 lakhs 90,000. Khordha. Therefore, the Khordha inspection was done. It was declared it is within 5 crores. The list, if you are to look at page 236, the list is there. The auxiliary item is page 237 and 238. The old and obsolete machineries, the items excluded also there in list 2. Then the list of plant and machinery found working at page 239. It is within, that is 4 crores 59 lakhs. 4 crores 48 lakhs 90,501. But this is in 2015. But similarly, they used to inspect periodically and grant the registration and certificate according to merit. What I beg to submit before what says that this is one of the industrial undertaking which comes with the definition of enterprise. Now, sir, kindly turn to the next order. It's a continuation, Malad. At page 50, Malad. That is 7/4/2022. The petitioner has moved court praying that the proceeding initiated by opposite party number 1 under section 18 of the MSME Act and order dated 28/6/2016 be quashed and set aside. The writ petition was heard by this bench on few occasions. Mr. Das, a senior advocate appearing on behalf of the petitioner, had earlier submitted challenge in the writ petition is directed that in proceeding concluded by order dated 28/6/2016 is arbitral reference on the Act. Short point is that our holder cannot be said to be supplier within the meaning of clause N of definition 2 and subsection 2 under clause A in subsection 1 of section 7 limits enterprise. Such an hour holder is being called a small enterprise to those whose investment of plant and machinery is more than 25 lakhs but doesn't exceed 5 crores. He referred to page 110 and 111 of the writ petition to show that the schedule of fixed assets of the opposite part number 2, it had plant and machinery as on 1st April 2010, 6.5 crores, and the same on 1st April 2011, 5.47 crores. This is relevant information in relation to claim of payment made and forwarded as a demand on the Act by the opposite party. So kindly turn to page 86, 87, and 88. That's it. Good. Page 86, Madam, can you see? This document was shown to your WhatsApp last time also. As you were can you look at the top part, Gupta Power Infrastructure Limited, Schedule E fixed assets, schedule forming part of balance sheet. Am I clear, Malad? This is a balance sheet of profit and loss account. Then serial number 2, plant and machinery. Malad, got it, Malad? Malad, third item, Malad, in the table. Third item is first page 86, and it's a 7. Serial number 1, 2, 3, land, land leasehold, then plant and machinery. They have taken your ships to, the date is 31/3/2011, 6 crores 54 lakhs 70,000. Now kindly turn to page 290 here. 290, Malad.
Certificate of the chartered accountant.
Yes, Malad. This is chartered accountant, Malad. But this document says this is a company's books of accounts. This is financial statement. Or this financial statement is given. Kindly turn to the table, Malad. Khordha 2.5 investment in plant and machinery. Then Uttarakhand Unit 1 4.1, Uttarakhand Unit 2 0. The Gundipuli, that is Chennai, 3, that is 654 in total. We are concerned about Khordha unit, Malad. Company files balance sheet of all the units. That's a different matter altogether. But so far as the plant and machinery concerned, of Khordha is concerned, it is investment is 2.5, available is 2.50, it is below 5 crores. But this document was shown to show that it is altogether more than 6.5 crores. But similarly, that the next page, page 87, this is of the year 2012. Same thing, this is the total in the balance sheet. 5 crores 47 lakhs. Page 88 has been shown. If you also kindly see page 88. These are plant and machinery, auxiliary items. This pertains to all the 3 plants, Malad. This is for the purpose of balance sheet. It's not confined to one unit itself. One enterprise Now kindly turn to page 289. Relates to the certificate granted by Department of Industry and Commercial of Tamil Nadu. So far the Chennai industrial undertaking is concerned, the small scale industry. Since the other one is page 288.
These are not in dispute.
So these are documents they filed to show that the club together, they are trying to.
What there is, the question of the base. Then when the financial work to be enterprise is concerned,
Right,
whether all the units to be clubbed together or not.
right.
That is the issue.
So issue here I am trying to explain to your lordship that they say it exceeds 5 crores. So far as this industrial enterprise is concerned.
You say that we are concerned with the supply.
Yes.
That is your case.
That is right. So I wanted to show because they are referring to these documents to tell your lordship that this shows that it is more than that, more than 5 crores. Those things cannot be taken into consideration for the purpose of calculating whether my industrial unit, plant and machinery is more than 5 crores or less than 5 crores. If it's clubbed together, definitely it's more. It cannot be clubbed together.
I think they should be clubbed together.
But I beg to say, question of clubbing together doesn't arise in the present case because each one of the industrial undertaking is independent and has to be considered as per definition as each unit is one.
I think where the entire controversy is based, because suppose you have one unit producing certain materials, unit number 2 is producing certain materials, and the unit in Khordha are assembling these materials. Even by a technological process, you cannot say that these are different units.
It has not been assembled together that way.
No, I am just giving an idea.
Exactly. It is not done so here.
No, that is what.
Right. These are all independent and individual. We supply from this plant, another supply.
That is not right.
That is admitted fact, madam.
No, that is their contention that that should not be taken into account. They should be taken together. Yours is that it should not.
All independent.
Yes, all right.
But that order itself will reflect also, also from the order itself and from the order of the Honorable Single Judge. Then sir, kindly turn to paragraph 3.
That they are challenging. That is
challenge. Taking us back to the investigation.
No, sir, facts I would like to show to one thing. The Honorable Single Judge has dealt with the matter in detail, each and every aspect. What I wanted to say, no ground to interfere with the in appeal. The reason being that is exactly the reason for which I am taking your worship to the order. But a lot of time has been devoted by the Honorable Single Judge in hearing in detail. All at length detailed argument has been made on each and every aspect.
Unfortunately, we are not there yet to go by the records.
And another thing which the learned single judge said that there were so many sittings. That is an error of sittings before the council.
Yes, madam.
So that number which has been given, that is not correct. That is the serial number of the sitting, not the total number of sittings.
So that is madam, so 45.
Yes, exactly.
That is a mistake, recording mistake. 45th sitting, 38th sitting, 33rd sitting, not 48 times, madam. But there are a number of sittings. So it's not that only one sitting. No, madam.
Those orders are before us.
Number of sittings.
2 or 3.
It is not 45 sittings. It's a 45th sitting.
You have understood. We have understood.
Exactly, madam. That is a mistake, madam, in typing mistake, madam. It is not that the court said 45 sittings. No. It was never argued. Never is the concept of that. But here's the case that number of sittings were there by the conciliator also, the council itself. But they have taken note of each and every aspect.
The whole question can be appearance in ways that whether you to come within the financial, the proceedings they have.
Yes, but that has the what I want to say, madam, on fact finding.
Otherwise, the entire procedure that has been followed.
Yes, correct, incorrect. Absolutely correct. Well, what I want to say, these are all factual aspects. Court has examined it, the arbitrator has examined it, court has examined it, they found it to be correct. So what is the procedure to be, not Article 226? It is not the patent illegality which the root of the matter, like I say, without jurisdictional issue.
That is what they are saying, not
lack of jurisdiction or some matter where the Article 226 is to be invoked. The procedure has been followed, not the way actually somebody wants it should be followed. What happens in these matters, if you actually kindly see, the pleadings are filed by the parties, then the conciliation starts, conciliation fails, then the arbitrator becomes the same person becomes the arbitrator, and he adjudicates the matter. So what is to be adjudicated? It's all admitted, It's all, I'll show you, it's all admitted. The dues are admitted.
No, that it is that within 5 crores, is that admitted? That they're disputing?
Yes,
That has not been decided.
I'll show documents, my lord. But forget about that, my lord. But you also can see Dr. Murali's Chief Justice order, my lord. Last order. Can you give me that order? Can you see that order? Sir?
Why are you referring this order?
Sir, referring this, Honorable Court suggested there is no dispute that outstanding dues are there. 1 crore, let us fix it. Interest, you calculate.
We are not on the outstanding dues.
Maintenance.
We are not on the outstanding.
Sir, what I wanted to show you, Lordship, they never disputed that. But there are 2 letters are there, they admit the dues.
No.
Quite clear, my lord.
All right. Not your point.
But these matters actually, if you understand why this statute was enacted. Statute was enacted to see that a person who has supplied and gets the money back. If he delays, then with interest, compound interest as is provided in section 16. My respective solution for Lordship is that, well, they admit dues are there. They wanted to settle at 64 lakhs, 73 lakhs. But that those 2 documents are there.
We are not looking into this document.
Sir, exactly.
Appreciating these arguments.
So they themselves have filed it in the writ approval.
Whatever we have understood so far here, there is no 2 aspects. The fundamental question of the jurisdiction and the procedure that has been followed is very wrong.
So procedure has been followed in one way. But those 2 decisions that have been cited before Lordship, kindly have a look at those 2 decisions. Kindly have a look at those decisions. I'll explain to you, Lordship, whether it has been followed or not.
We have seen, we also read out.
Now that, Lordship, kindly see first decision, Urja's decision. Okay? I'll show you, Lordship, why the decision is not right.
Only the relevant part you can show.
Only the relevant part, madam. Only the relevant part. I'll show you also the relevant part. Now you can know. I'll show the relevant part. I'll show you Lordship the relevant part. I'm not Well, can you see that Urja December 2021 SEC online 1257? But yes, we got the decision, I think. Paragraph 2, let's make can you see. Paragraph 2. The appellant herein, which is the successor company of the erstwhile Jharkhand State Electricity Board, entered into a contract with third respondent, so also supply of ACSR Zebra conductors. No, I want to show that in law has been emanated from the facts, my lord.
No, don't do this. Because the question he wants to come to the relevant position would be you are to that.
Here the appellant didn't appear in the passing award, my lord. That is what exactly the Lordship say. Can you, my lord, paragraph 11, my lord. 11, 12, 13, 14, 15, my lord. Procedure has been specifically mentioned from reading of 18.2, 18.3 of the OSB Act is clear that counsel applies to conduct conciliation for which the provision of 65 to 81 of the Act would apply, as if the conciliation had initiated with Part 3 of the Act. Under Section 18.3, when the conciliation fails, the stands terminated, the dispute between the parties can be resolved by arbitration. The counsel is empowered either to take up the arbitration of his own or refer the arbitration proceeding to any institution as specified in the said section. It is open to the counsel to arbitrate and pass an award after following procedure under the relevant provisions of Arbitration Conciliation Act, particularly section 20, 23, 24, and 25. There is a fundamental difference between conciliation and arbitration. In conciliation, the counselor assists the party to arrive at an amicable settlement in an impartial, independent manner. In arbitration, the arbitration tribunal arbitrator adjudicates the dispute between the parties. The claim has to be proved before the arbitrator, if necessary by adducing evidence, even though the rule of the Civil Procedure Code or Indian Evidence Act may not apply. Unless otherwise agreed, oral hearings shall be held. If the appellant has not submitted his reply to a conciliation stage, fails to appear and facilitation counsel could at best have recorded the failure counsel and proceed to initiate arbitration proceeding in accordance with the relevant provision of the Act. to adjudicate the dispute and make an award. Proceeding for conciliation cannot be clubbed. In this case, only on the ground that the appellant has not appeared in the proceeding for conciliation on the very first date of appearance, on 6/8/2012, an order was passed directly appealing to pay. Nothing has been done in this case. The council has not done anything. Yes.
That case where the starts, at the same time when always passed.
Yes.
Without recourse to the arbitration and after the sector, section 34 of the state will not apply. You cannot reject this and you only on the ground of the
Exactly.
Section 20 of the
Well, that's exactly. This is not our case, Malan. But the law principle that has been reduced by referring to different provision of the statute itself. But here, then and there, the hour has been passed since it didn't appear. Without initiating in proceeding, arbitration proceeding.
Reference to the factual aspect of the matter, your submission is very correct. But the law, proposition of law also has been laid down in paragraph 50.
Yes, I agree. I agree.
Arranging the particularity of the reproduction.
Sir, here the provision that has been settled is correct. Well, I don't dispute again.
That's all.
Yes.
That is interpretation.
What I like to say, this decision on the materials on record in our case is not applicable.
All right. All right.
They are actually then and there the hour has been passed. In the other case also similarly, paragraph 3, let's me kindly see. Paragraph 3, that Vijayata construction matter. By order dated 10/1/2012, the Facility Council closed the said proceeding by observing that.
Just a minute, Mr. What is the second one?
Sir?
What is the second decision?
So Vijayata construction 2021 SCC online 3436.
All right.
Paragraph 3, Malat. That emanated the
first.
By order dated 10/1/2012, the Facilitation Council closed the said proceeding by observing the council has constituted with the limited object jurisdiction. Facilitators Council has no jurisdiction to make through inquiry and take evidence and decide the truth about the challenged document. That is why that order was challenged. And the eventual result is, if you also turns to paragraph 14, 15, and 16, by referring to the provision of law, in the light, paragraph 14, Marat, in the light of the aforesaid statutory provision under MSME Act as well as Arbitration Act, the order passed by the Facilitation Council dated 10/1/2012, which was the subject matter before the High Court is required to be tested. From the order passed by the Facilitation Council rejecting, dismissing the reference, and the stage at which such an order has been passed, we are of the opinion that the Facilitation Council has not followed the procedure as was required to be followed under Section 18 of the MSME Act, wherein Section 65 to 81, as reproduced therein. It is required to be noted that at the initial stage, the Facilitation Council was performing the duty of conciliator, for which provision of Section 65 to 81 shall be applicable. It is true that the stage of conciliation, the role of conciliator, Facility Council, is to assist the parties to reach an amicable settlement of their dispute as provided in Section 67 of the Arbitration Act. At that stage, the parties are not required to lead evidence. At that stage, the role of conciliator is not to adjudicate the dispute between the parties, but to reach an amicable settlement of the dispute between the parties. Once the conciliation fails, thereafter, as per subsection 3 of Section 18, the arbitration proceeding commences, the council proceeding stands terminated, and thereafter, the Facilitation Council shall itself take up the dispute if the statute has been quoted, Marat. But in the present case, no such procedure has been followed by the Facilitation Council as required to be followed in Section 18. That is the reason why, while emanating or reproducing the entire procedure, they say you have committed a mistake. It has been crossed. But here, if Lordship may I just take your Lordship to the order itself. The Honorable Signatures in paragraph 4. He further submitted all supplies were made to the petitioner from unit Khordha. Am I clear, my lord? Paragraph 4 at page 52. He submitted further that all supplies were made to the petitioner from the unit at Khordha. The supplies were made by his client in the year 2009 to 2013. His client had certification as on 6th May 2018. That's 2008. That is Annex page 66. I have shown the registration certificate for Khordha unit. Being disclosure in the writ petition in page 75. The order of supply is dated 30th June 2009. And the supplies were made pursuant thereto as contemplated in the year 2013. On 4th March 2022, hearing of the writ petition was on circulation dated 29 September 2015 and 3rd March 2016. Relevant text, so I need not show you worship, all those things I have already shown you worship. Then kindly turn to paragraph 6 at page 54. Paragraph 6, minute. On 16 March 2022, Mr. Das reiterated his submission earlier made. He referred to additional reply on behalf of opinion number 2, 2nd December 21, page 17 to show that on addition to the plant and machinery totaling 9.32 crores, that I have already shown you a I did not show it again. Page 271, page 86, 86 and 87. On query from the court, he submits that claim was made by the said opposite party for the council on supplies made from Kasipur unit, but later withdrawn. But they initially wanted to raise jurisdiction where Kasipur unit supply was also included in the Khordha unit. The total amount was claimed. Subsequently, that has been withdrawn by me, saying that no, Kasipur is an independent body, therefore I don't want to raise it. I want to confine my claim to Khordha unit itself. Therefore, that has been withdrawn. That order has been passed by the council also, and also taken note by this honorable court. Then they have referred to different judgments that have been discussed here. And sir, kindly turn to paragraph 9. Page 57. On the question of maintainability of the writ petition, the matter of arbitration, submission was made on behalf of opposite party number 2. It is not maintainable. Award has been passed and remedy of the petition in event petitioner seeks to challenge it is under section 34 of the Act. Contrary submission was made. There has been demonstration of it being a rare case where there should have been judicial review of wrongful invocation of 226 Act and in any event violation of prescribed procedure resulting in interim award. The fact will appear from record of submission above. Opposite party number 2 had certification on 6th May 2008 for its Khordha unit, from where admittedly all supplies were made to the petitioner. The supplies were made under purchase order dated 13 June 2009 and supplies were completed in 2013. Opposite party number 2 alleges non-payment and alternate approach the council under 2006 Act. Interim order dated 28 June 2018 says total supply value was in excess of 36 crores. Upon adjustment of part payment, balance amount outstanding is 1 crore 93 lakhs 81,000 and claim of 4 crores 98 lakhs 60,000 or was filed for the council by opposite party 2. That is the interest matter. The council held 45, that is 45th sitting actually, not 45 sittings. It's a wrong noting actually. First court, because the order also shows of the council is 45th, not 45 sitting. The first court must deal with the challenge amounted to contention of that opposite party number 2 cannot claim itself to be a small enterprise. The invocation mechanism of 223 Act, the certificate of 6th May 2008 in his date prior to the purchase order, Dispute arose on the part of the payment for the supply of remaining outstanding. Prayer in the writ petition are for interference with the award. Scope of prayer is not include the challenge, the certificate itself. The issuing authority was accordingly not imputed as opposite party. In Vidya Dhulia, the Supreme Court had declared interpretation of judgment in rem. The certificate cannot be equated with the judgment in rem. The authority issued the certificate on being satisfied that the opposite party number 2 is Khordha unit was eligible to have certification as small enterprise. There is no question of petitioner being privy or party to the proceeding in pursuance of the certificate simply because the petitioner had not applied to the authority as supply connected to opposite number 2. The Vidya Dhulia is not aid to the petitioner. Petitioner also contended of clubbing. Nothing further, but they say that they are not. Kindly see, the court has taken note of that also. In paragraph 13, petitioner had also contended on clubbing. Nothing further in addition to what has already been said in the order dated 4th March 22, already dealt with that matter. Extracts and quoted above is required to be said. Regarding procedure followed, culminating the impugned award. Well, that is one of the ground taken with regard to procedure matter. That has also been dealt with matter. In the impugned award, on perusal of it, court finds that counsel had submission made to its on behalf of the petitioner that there would be an amicable settlement. Few paragraphs from the award are extracted and reproduced below. The opposite party filed time petition to file counter to the rejoinder before the council in its 38th sitting. Now, sir, kindly have correctly quoted 38th sitting. The council allowed 50 days time and directed both the parties to have an amicable settlement within 1 month as agreed upon and report the same to the council. Both parties were present before the council on 42nd sitting of MSM on 21/2016. The petitioner submitted before the council that the case is pending since 24/4/2014 and unit is facing financial hardship for pending of his claim on opposite party. Initiating the discussion, the advocate on behalf of the OPs submitted before the council that the management of Gupta Power is in touch with the management of JSW Steel, Karnataka, to have amicable settlement and prayed 7 days time to intimate this outcome to the council. In response to it, the representative of the petitioner declined to have such information to the council. As a result, the council may go ahead towards disposal of the case. The council went through the deliberation made by both parties and directed OP to have amicable settlement with the petitioner and inform its outcome to the council within 7 days from today. On 21/2016, if no communication is received from OP within the stipulated period, the award shall be given for payment of outstanding due with interest as per MSME Act. It does appear the council acted as a counselor in allowing parties to arrive at an amicable settlement. Then further submission was made. This is one part over. The further submission was made on her petitioner by reliance to subsection 2 of section 18 and section 80 of the Arbitration Act. Mr. Das submitted that councillor cannot act as arbitrator. Now law has been settled, my lord. So that decision also I will produce before Lordship. It says what are the points that have been adjudicated. The special statute overrides the arbitration, the provision of the Act also. We are referring to section 43 and other provisions. It says the councillor cannot act as arbitrator in this case. He submitted. If the council is held as having cause conciliation, then it could not thereafter itself have adjudicated the dispute as arbitrator. It's no more recently emerged. Then through section 80 of the Act says, unless otherwise agreed by the parties inter alia, council had not acted as arbitrator, but section 18 of the Act says, inter alia council shall either itself conduct conciliation or seek assistance in the matter. Where the conciliation initiative is not successful, the council shall either itself take out the dispute. The Honorable Court said that they have discussed the matter, but I'll take your lordship to the award itself. I'll show your lordship the award has dealt with the factual aspect, and after the conciliation failed, the proceeding of the matter. Kindly turn to the award. First, Annexure 12 notice. Annexure 12 at page 159. It is supposed to be. Just our text is page 216 also you can see. Provided 16 or got it. The MSME made on 28/6/2016 with 10 AM to arbitrate the claim of micro small enterprise Ms. Gupta Infrastructure was a JSW matter. He has referred to the factors where the total supply was made this. We kindly turn to page 217. Both the parties, third paragraph, after thorough examination, it is found that petitioner submitted 3 number of tax invoices from Kashipur, Uttarakhand, which is not the jurisdiction of MSME also. Both the parties were present before the council in 34 sitting, held on 12/12/2014. Advocate on behalf of OP submitted a written statement that the respondent was out of station and paid adjournment of the case to another date. Council ordered the petitioner to file a rejoinder within 7 days and drop the 3 invoices raised in Kashipur, Udhamnagar. In the meantime, the petitioner filed a rejoinder on 11/2/2015. In pursuant to the order of the council, the petitioner has filed revised calculation sheet claiming total amount 5 crores 3 lakhs also, principal 1 crore 57, interest amount 4 crores and odd, up to 31/12/2014. The same was forwarded to the OP to file counter. OP filed time petition the counter rejoinder before the council on 38 sitting. The council allowed 15 days time, directed both the parties to have an amicable settlement within 1 month as agreed and reported to the same council. Then both parties were present before the council in 42nd meeting on 21/2016. The petitioner submitted before the council that the case is pending since 24/4/2014 and the unit is facing financial hardship. Initiating the discussion, the advocate for OP submitted that has been quoted by the Honorable Single Judge also. Yes. This para. Then the counter that has been filed, that's taken note of. Kindly see the counter at paragraph 5, Maran. 3, 4, and 5. The OP suggests that claimant should produce appropriate document to substantiate the compliance of section 7 and 8 of the MSME Act. That is the certificate that was also filed. OP admitted that he has purchased various items as described in the purchase order issued from time to time. The claimant between 2019 and 13, the total basic amount for all the purchases 328.21 lakhs 127.711. OP submits the detailed information Annex R and R3. Total basic amount so and so, total invoice amount is so and so, total paid amount this, total adjusted amount is so much. But adjustment cannot be unilateral. You cannot make such an adjustment. But OP said that excise amount so and so is mentioned. Then page 219, which we can see. The petitioner submitted first statement answer excluding the 3 invoices of Kashipur. That was excluded. They have also disputed that this unilateral cancellation is also bad. Then page 220. That in few purchase orders are misquoted in as much as there has been mistake in quoting the purchase order number. There's only a typical mistake, but the fact remains both supply and value of the invoice mentioned are true and correct. Both the parties were present before the council on 45th sitting of MSME on 28/6/2016. The petitioner had stated that case was pending since so-and-so. and the case may be decided by the council as per MSME Act. The OP stated that the petition was not an SSA unit. The council examined PMT registration certificate, part 2, and concluded that unit is a SSA unit. Further, the council observed that the case was heard on 29/12/2014, 15, and 2016. The council has directed OP on 21/2016 its 42nd meeting to make an amicable settlement writing within 7 days. But the conciliation was failed. In the meantime, OP will file additional affidavit on 27/1 and 21/4/2016. The petition filed is counted for the court on 28/6/2016. Council went through the relevant documents filed by OP and so and the counter of opposite party and decided to pass an award as follows. Since the conciliation was failed prior to that. So that is how the court has decided the matter. But eventually, the award has been passed. My respective submission, the award can next place. They are present when the hearing took place. They participated in the hearing. They never raised any objection that no hearing cannot take place. They have never raised any objection that we want to give oral hearings. They never raised objection we want to file additional documents. They never raised anything. They participated in the hearing. The hearing took place so far as this arbitration part is concerned. Once they participated and the adjudication was made, whether it is correctly made or incorrectly made is a matter to be challenged under Section 34. But all these grounds they have taken, limitation, all those things. But if you also looks at Section 34, you know, so detailedly heard the matter in the other case. But the power in Section 34 and what are the questions which comes in 34. So 34 subsection 2 and 3 are the only power in which if no, why is
this? No, you only stop there. That their remedy was on the section
34.
Stop there. Don't go and agree to the 34.
But I wanted to say you see already I want to take a receipt to that.
Don't say that. You said it only 34. They have not even that option that
Exactly. Sir, these are all facts. No, procedure has been followed. If it's a wrong procedure or incorrect procedure, then you have to challenge on Section 34. But it is not a case where procedure has not been followed. But we can resolve one thing. Not following the procedure and following the procedure in a faulty or wrong way, that's two different aspects. Here, procedure has been followed. If you want to find fault in the procedure, challenge 34. Because 34 you have to challenge section. But one more decision I would like to cite latest after these two judgments were one more judgment has been the time. It a copy दीजिए.
There's already declared theirs to go see the court.
Oh, I'm sorry, I'm extremely sorry, The judgment you should take what is saying? This 2022 SSC, after those two judgments, first this judgment, latest judgment.
Manage one item 54.
Item 57.
Just a moment.
Tomorrow 3 p.m.
Item 54.
He hasn't finished. He wants to cite this judgment.
Well, I have no objection. Your Lordship may hear him. Please allow me to rejoin virtually for a few minutes.
Sure.
I'll join virtually and I'll submit a two-page written note, my lord, if your lordship so please. And I will rejoin virtually. I need only a very few minutes for rejoinder. Obliged.
Item 54. It is fixed today. Discharge ambition against which have come up with government side and social secretary. Which is also fixed today. So I pray. Since it has come up, but it has not reached. So only I make it there. Only day it can be taken up at 2 p.m. Any day, as per your lordship's convenience.
My lord, I mean, orbit.
No, mention. Item separate the Niyama file. Item subject to possible appearance is there, my lord. Appellant is physically present, my lord, in court. Item 72.
Item 71 में फॉर्मिन my lord.
Tomorrow, yes, my lord. Order dated 3/7/23, my lord. Last date, last occasion. Order dated 3/7/2023.
What is the new judgment?
Para 3, my lord.
It's under what?
Yes, yes. 3/7/2023, my lord. Yes. Para 3.
That noting causeless people, the assistant has not made the note properly.
It's on causeless only. Oh, this judgment I know.
They're not taking the noting properly, very careless.
Consideration Act.
Yes. So you are appealing for them?
My lord.
No, 72.
72, my lord.
You are appealing for them. That is the problem, that you are not appealing for the clients. That is the order of the 3rd July. The paragraph 4.
My lord.
That is why personal appearance was directed.
Yes, my lord. Yes.
Appealing to the appearance 463, 46, 463 and 464.
Not a victim.
Yes, submitted that the appearance is not in person and come to the latest report in Senate. So Mr. Pandavan counsel stated that you appear on the next page for hearing and you cooperate with the procedure. In terms of the appearance of the occurrence of the people number 460 and 464 are discussed for the time being.
495.
What is the good name, sir? 495?
My sir. नाम वीरेंद्र कुमार रावला.
नहीं आपको
रविंद्र कुमार रावला.
रावला
And counsel is appearing as appealing number 495 after the appeal. The same appeal is also present because in terms of the state order, it's not related. Free. Dispense the personal appearance of the appeal. Here, Mr. Raura has other two that will participate in the proceeding. Whenever the date is fixed for hearing.
Lordship mentioned item of the lordships, part are metal lordships. Tomorrow lordship? Tomorrow it will be on the list, lordship rolling in the list. Tomorrow.
465.
Day after tomorrow is Friday lordships because
Item 57, right? Item 57. Minor girl has been kidnapped since about 1 year. Not yet been
Item it was almost the argument is over. Only Lord and Council for the state was to take instruction in the matter. Well, that is also can be recollect that is the virus of JRS employees.
I understand that we have filed affidavit, they have to give reply.
No. You have to take instruction.
So the instruction of all
applicable.
29 is parted for continuation again.
Lords.
It is passed against. Item 16 to be taken up, date will be given, next date is.
My lord, I may permit my lord. My lord, I may permit my lord. Item 71. Substitution petition. Your lordship can take up next week for orders, my lord. The substitution petition has been filed.
All right, it will be taken about 31st.
Yes, my lord.
Okay, what is the item number?
Item 71, my lord.
71.
71.
Yes. Do you have anything to mention?
74. 74. The last occasion I have mentioned before your lordship, WPC 5129 of 22. That has no relation with this elephant corridor matter, 74. This is separate matter. This may be dealing with it.
This item 72.
WPC number 5129 of 22.
mention
Item number. What is the WPC number you are mentioning? Item number 72.
74. Item 74.
Oh.
That matter is coming on 29th at 2 p.m. That matter is coming.
No, nothing happened to us.
What is the your petition number?
WPC 5129 of 22.
Benudhar Patra.
To be dealing. That is to be delinked and separate 72. Item 72. WPC number 5129 of 2022. Be deranged from this batch of petitions, and the same matter shall be listed separately on 29th. No, this might be 29th August 2023.
56.
That is because of assignments.
Yes, item 56, madam, that is motor vehicle matter is not reaching matters. Today,
we are trying very hard to reach the matters.
I not see that.
All right.
At top of the list,
All right, this date will be given, shorter date will be given, just wait. Otherwise, make mention on other date.
the seat through interim order is still good.
Item that was
42.
only 42?
Yes.
Must be 2 matters there.
Item 42, there are 2 matters.
I don't know,
The matter on 11th of September. Interim order is passed earlier, shall continue.
item 53. 53, my lord. I interim order to continue. 43, my lord.
Same order, huh?
Item number 63, you're taking up your lordship convenience.
The date will be given, I told you.
54, interim order to continue also.
54.
Interim order to also continue.
Yes.
There are two appeals. CRL 455 in connection with Vimal Kumar Khetan, he is the husband of the deceased.
Let's start here now. So, 430. We have already reached 425.
Yes, but that's it.
So, yeah, just a search for a date, very close date, because we have heard for some time.
September.
Huh?
September.
Because there's no difficulty. The first week of September, find out when the date is there. Only two dates are available, not 4, 5. 11th of September. 11th of September.
11th of September. It's at 2 o'clock.
No. It will be on 3:30. Because it will be break bench. No, 2 o'clock is not possible.
Can be 3:30, that will give some time. 3:30.
That is why you are fixing 3:30. Okay. Just as there is no time to hear the matter today. The matter will be listed on 11th September 2023 as forward for continuation of hearing at 3:30 p.m. Mr. P.P. Pradhan, Mr. Kotukia, Mr. Just last days already follow in order now, right?